to announce the board members. Myself, I'm the president, Trish Gibson. Catherine Nelson in the back is the vice president. Christy Bybee is the secretary, and Sean Ellis, who's not here in attendance today, is the treasurer. And then we have the directors. We have Suhair Sage, Nicole Marley, Dalton Hooks, Trudy Johnson, Kevin Campshire, Miguel Delgado, Glenda Lee Jackson, Dr. Matt Keoch, and Brady Davies, I say that wrong. And then I just want to direct you guys, we have our website is up, it's nbndpc.org for registration, for questions. If you're already a member, you can look at old trainings. We don't have that set up yet to do the CEUs through that, but we're working on that, so hopefully that will be something that we can offer you guys down the line. You do have to be a member to get the CEUs, and membership information is in that portal. But anyone can attend. Anyone can come in person, listen online, it's open for everyone. And I do the CEUs, so at the end of the course or within a few weeks, if you don't have your CEUs, please reach out to myself or Christy. They do get missed. Sometimes your numbers are wrong. Sometimes I don't have the right information. I usually try to email you and get that just to make sure, because there's a limited amount of time that you can actually get the CEU after you complete the course. I can't do a lot to fix that, and people get missed, and we apologize, so please reach out. Don't feel like you're bothering me. I'd rather check and tell you that it's done than you miss out on getting your CEUs. And then our sponsors this morning, our platinum sponsor is Complex Ancillary, that's Catherine Nelson. Silver is Streamline, that's Laura Gannon, she's not here this morning. And of course, we'd like to thank the Las Vegas Valley Water District for letting us use this space for all these years, and we sure enjoy it, and it's a perfect venue for us to hold these trainings for you guys. There's breakfast in the back and coffee. I don't think anybody has any questions already, right? We don't have any questions? It just says open forum questions. Catherine, do you want to come up and speak? And then Ann will be our moderator today. I'm stepping in. She will be here shortly. I'm not as good as she is, so please be nice to me.
Good morning. My name is Catherine Nelson with Complex Ancillary, and we actually provide DME, in-home health care, home and vehicle modifications, hearing aids, orthotics, and prosthetics. What kind of sets us apart from the other DME companies is we actually have a DME warehouse right here off of the Cheyenne and the 95. We have our own delivery vans, and we have technicians that are trained on how to help people set up like CPM machines, hospital beds, things like that. We also have a project manager. So if you have a home modification, our project manager actually goes out and makes sure, she works with the contractors to make sure everything is staying, kind of on time, everything's moving, make sure everything that is being done is only medically necessary and not something that, they want granite countertops and they had coriander or something like that. So she kind of makes sure that everything is efficient and exactly what's needed for that injured worker. But if you have any questions, I do have brochures and I have some notepads back there. If you want to take our information, please give us a call. We do discharge planning as well, which is really nice because we have the drivers. So if you call us at 3 o'clock in the afternoon, say I need a CPM, I need a hospital bed, and they're going home today, get it out there, we can get it out there for you. You don't have to pay for that extra night in the hospital, which is a lot of money savings for you. So let me know if you have any questions, but we are here to help. Thank you.
Thank you, Catherine. And then we'll get started. We're doing adjuster ethics today. You guys may have had ethics before. If you need ethics credits, they will go towards ethics credits. If you already have them, it will go to regular CEU credits. So you'll get the credits either way. I know somebody said they needed 2 ethics credits, so it will be 3, but it will go to that. And so we have Kevin Campshire and we have Dalton Hooks as our panelists today. So take it away, guys. Let me turn this off.
If you guys want to do your bios, you can, in case somebody doesn't know who you are.
No,
Exactly. I'm not
I'm not
No,
mine.
no.
Yeah, it's
Everybody
on our
knows.
website. All the
Yeah.
more reason to go to the website. Yeah, no.
Agree.
So before we start, is that some of the information now in regards to ethics, so as you know, it's like every January, Sean Meng and I since like 2020, have done the ethics presentation. We're also doing it at the DIR, or a version of it at the DIR conference this year. And so what we determined is that we dove into some pretty particular instances with adjusters that, you know, raise ethical issues. And some of you, if you joined us last time, may remember is we left off with a topic about the unauthorized practice of law. And so we're going to go over some kind of very basic things, because when you talk about ethics, there is overlap, and you really do need to review the foundation. Everybody does periodically. But so it is going to be today, you know, when Sean and I do the presentation, it is a real broad overview of everything. And so broad overview not only deals with adjuster ethics, but also with attorney ethics, ethical obligations I have to my own client, ethical obligations like we have. I mean, you know, it's broad. It's really, really broad. So what we wanted to do is narrow it and tailor it mostly to adjuster ethics. Now, granted, if we didn't talk about some law, then I wouldn't be able to talk on the panel, and that would be devastating. So, there are some specific things in regards to that I will share about ethics. It is very easy, okay, to try to veer off of talking about ethics, because the ethics involve everything that we do every day. So we're not here to talk about substance. We're not here to talk about litigation. We're not here to talk about all of that. It's like, what is your ethical obligation, if any, you know, quite frankly, sometimes with that. Dalton is stepping in here. Now, he and I have not been on a panel together it's been a while. So
Yeah, the eagle-eyed people in the audience and online have already recognized that I am not Sean Meng. But I can do an impersonation. Hi, I'm Sean Meng. I have a bunch of kids. I literally have one in every grade, K through 12.
We're going on a cruise.
All right, anyhow.
Yeah, just some of the basics, and then we will start with the unauthorized practice of law. However, but I just want to start with something before we even dive into anything. It'd be interesting to see what people's opinions are, and you can see how this plays a role. So we started this, like I said, in 2020. So we did it in January of 2020, and then we decided that we wanted to do it north. And so in March of 2020, notice the timing, March of 2020, we all went up to Reno and did the ethics presentation. It was amazing. We got great feedback and all of that. Well, I mean, we all know what happened in March of 2020, and it was all actually unfolding as we were flying up there, because we had discussions the night before, the morning up, should we even go, should we do it? Of course, we're all like, yeah, you know, so we went. I think Sean blames me for getting COVID to this day. I mean, jokingly, but tons of people did.
He was patient one.
Yes.
He was the first one.
Yeah, and I got it, I think, because I was in South Beach right before that, and it was just exploding, and so nonetheless. The reason why I bring that up is I'm just going to pose how you can see just simple things, okay, can involve your own ethics, and sometimes it's your own thoughts. So COVID, now in retrospect, when it was all happening, we had no idea about tons of things. In retrospect, we have all this information. I don't know if any of you know this, but I don't remember if it was in 2020 or if it was in 2021, but I think 2020, Nevada, okay, like gave businesses, they passed like a law which pretty much gave businesses absolute immunity in tort. I mean, guess who they were protecting, you know, the casinos, about being sued, you know, in tort for COVID, you know, for contracting COVID. You know, we could argue whether or not that's absolute immunity of business is a good thing, bad thing, whatever they did it, okay? So then what ends up happening is that, so if you're a casino worker, the question was, all right, well, if I contract COVID, I'm pretty sure I got it at work. And so they have to file a work comp claim. And then, of course, we didn't know, or that, you know, the employer, of course, didn't know where they contracted it. So you'd see denied claims, you know, things like that. But again, in retrospect, then, of course, we got the vaccines. And then remember, some people took it, some people didn't. It became this, like, real hot button issue, which I still to this day don't get. But I want to, you know, pose that to you everybody had, and some people, very strong feelings about COVID vaccines. And, you know, some employers were even requiring, or, you know, someone would get it and they'd be out sick for 10 days or something, and the you know, and then you'd have that HR manager be like, well, you didn't get the vaccine. I mean, there was a lot of that going on. So I mean, that's the whole thing. You can see, I mean, does anybody have, any thoughts or at least can see that how your ethical obligations in something like a COVID and something like a vaccine, okay, could play into your work and potentially, make you do something that's really not consistent with what we're talking about today and what your job is. So I guess if everyone wants to make comments or share anything, that's fine, but I wanted to bring that example because it ties into exactly what we're doing and the timing of when we started doing this and what all happened. And realities of things of how your own personal views can really taint what you're doing and you may not even know it. What do you think?
About COVID?
No, yeah. I mean,
I
well,
don't know.
also
Thank God
remember,
it's behind us.
right? Yeah, I mean, and think, I mean, it's just a complete domino effect. Okay, so, but that is it can happen. I mean, you can switch out COVID to anything that you is going on. I mean, take your pick. There's a lot of content in this world at the moment. Take your pick of what's inflammatory or whatever, and think, how does that actually affect your work? I mean, we certainly do. We have to be aware of that in regards to ethics, is our hot button issues that we may feel passionate about.
Yeah, usually we rely on Anne to to grab the third whale for us, Kevin. So she's not here. Anyhow, she's on her way. Look, I wasn't here for the last version, the presentation,
She's
but
here.
speak of the devil, and there she is.
I got a 9 o'clock, gotta drop the kid off.
So, Anne, Kevin would like to know what you think about COVID as vis-a-vis ethics.
Right.
Welcome.
Without hearing any, those online. So Anne just walked in, okay, and so we want to, with her energy drink, okay, and so, now I just went through, I told the story about, remember when we first did this in Reno, and it was during COVID and all that. Yeah. And
We couldn't actually get a ticket. They were closing down all the airports.
Yeah.
And so we're wondering how we were gonna get home if we were gonna rent a car.
so the question ends up being, in regards to ethics, is of course in retrospect we know much more about COVID, and there's hot button issues like vaccines, and there's there's all kinds of things that stemmed from it. And so I was kind of posing a question to the audience of actually it was to Dalton, and he just laughed. So it was, what are your thoughts about all that? I mean, again, ethically speaking, now in retrospect we know a lot, but think of how all of these kind of different ethical issues that were created, and then that kind of led into what you personally think and how that can dictate, your job when it should not, and that's the summary.
You know what? I think a foundational.
You need a microphone.
I do?
Yep.
Unbelievable.
I know.
See, it's not working. It's perfect.
Turn it on.
Oh,
Can they hear
there's
her?
that.
Yeah. Ask if they can.
Can they hear her?
Whatever.
There we go. Yeah.
I think that's a great question because I think there were some ethical issues, but a fine line between making a decision because you've got something wrong inside your body and brain versus actually making an ethical error. If you intentionally, what the hell, I'm old.
Oh, God.
Can you imagine? If I was so much younger, I'd be so much quieter. I think the vaccines are a great example of it because they were completely full of shit. And as a result of that, I think the foundation of the people who created them understood that. I think that the pharmacy industry understood that. I think what was wrong was the fact that they got people to stand up and say to the people who believe, it's not bad, it's not anything, it's great, it's gonna save your life and your grandma. I think the people who were in the hospital defending were not making ethical choices because they were doing what they were told. I think the people who told us the bullshit, those guys made the ethical question to be deceitful. So I think when you're thinking about, is this right? Are you being deceitful do you know it's wrong? Or is your spidey sense going off? Because
My spidey sense is going off.
yeah, but I think that that's it. If your spidey sense goes off, you need to think a minute about where the foundation of your decision is coming from. Because your ethical error is when you say, oh, I'm gonna wait till 29 and a half days to answer this, versus saying, no, I'm gonna answer it right now. Or having 900 files on your desk and not being able to get to it to 29 and a half days. That's a different story too.
Well, so we got Ann's opinion on the actual efficacy of the vaccine.
Well, I'm just using that as an
Yeah.
example.
So then you're a perfect example. So then that feeling, how do you keep that out of the conversation with the employer you're having that is pro everything? How are you keeping it out of, the injured worker that didn't, or, you know what I mean? Is that that's
yeah.
kind of the point, is that so you have a strong opinion on something, and how do you keep it out of your work?
I think that's a great question, because where I'm currently working, I have quite a few opinions. And God bless Dalton as he put something in his mouth, because sometimes maybe I'm not so right in what I say. I think that's a great idea, and I think that as an individual, you have to make a decision. Are you going to work with someone who continuously challenges you ethically, who you know is doing ethically wrong things, and you are participating, whether it's passive or not, versus opinions? I can't change your ethics.
I'm asking you. You're kind of circling the airport here. How do you keep your own personal
I tell
feelings
them.
about COVID outside of it?
I tell them.
I know what my opinion is.
You know,
Yeah,
I
know.
tell them. Regretfully poor
The
Dalton.
employer, you tell you.
I
so-
do. I
Oh,
tell everybody.
you say vaccines are bullshit.
I do. I do. I'm not the example here.
Next
Yep.
slide.
No. You brought us into this
I-
quagmire,
Yeah.
Kevin.
I love it.
congratulations. So look,
Not my clients.
look, the slide I think that Sean helpfully created.
I did. I
You
think.
created this slide?
Not the high fiving. But
Okay, well,
the language.
The language? All right, fine. The slide that Sean and Kevin labored over to put together actually answers this question. What we're supposed to be doing is working together to make sure that the Nevada Industrial Insurance Act gets applied in this realm. So as adjusters, opinions aside, I guess this is very illustrative of the fact that people have different opinions about everything. As Kevin said, you can pick any topic today. We're polarized. Everybody has. I chafe at what our nation has become. I'm not a sports ball guy, but everybody does sports. We're just doing team sports. This is my team. This is your team. We're just going to be on teams. No thinking, no pragmatic solving problems, not getting things done, tribing up and being at each other's throats. That's the world we live in. That isn't the world that you get to live in terms of doing your job, discharging your duties under the Nevada Industrial Insurance Act as an adjuster in the state. You have ethical obligations so that you fulfill those. We got one thing to do. What does the law say that we're supposed to be doing here for this injured worker? They're entitled to benefits. I've been saying it since day one. The law says that people who are injured in the course and scope of their employment are entitled to these benefits when they're injured in the course and scope of their employment, comma, and not otherwise. My whole job is and not otherwise. That's it. And not otherwise. If it's in there, they get it. Her job is to make sure that she administers a claim in such a way that they do. His job is to make sure if that doesn't happen, that he is helping those injured workers vindicate those rights. And my job is to make sure that they don't overreach. That's it. It's a beautiful, simple system. Right? So that's why we're here. In terms of, I think, Kevin, I don't know if you want to do this slide, this general ethical definition.
Yeah, so we put together, so the thing about ethics, which I kind of love, is that, a lot of law has interpretation, obviously. We don't have the same interpretation of the law on something potentially that we're litigating or how it applies to the case.
Or
But when it-
facts.
Right, with facts. But the thing about ethics is that yes, there are, like for us, what?
That's a great
Oh,
slide.
thank you. I think this is, well, it was content, well, it doesn't matter. It was content actually because what we did before we did the presentation, this was back, well, Sean and I did, is got real information from, like, for example, I'm not telling you who it is, but ATPA sent us this huge kind of packet about ethics and what they teach their people, okay? And I thought it was like all really great information, so we kind of incorporated it into all of this. Because we can share, like lawyers have the Nevada Rules of Professional Conduct, and so there are specific rules that are, bright line about what you do, what you can't do, things like that. That doesn't mean that situations don't arise even daily that you don't have a particular rule or particular law to follow. You might think, well, I think that applies. 3 attorneys later might say, I don't think that applies at all, and I'm not doing anything wrong. So that can happen. But, so ethics are a system of moral standards or values, okay? Right, I mean, generally. Ethics also refers to, to rules or standards governing conduct of a profession or profession. That's what I was just talking about. And we're gonna talk about the NRS, about the actual ethical obligations of adjusters mostly today. Standards vary between individuals and organizations, right? So in fact, even sitting up here, our ethical obligations in regards to representation in this form differ greatly. If he's representing an organization, I'm representing individuals. Similarly, I do some criminal law, so I'm representing the defendant. I'm not part of the prosecution. And then an action considered ethical by one person may be viewed as ethical by another. That's what I just said. That happens a lot in law.
Well, it happens in our discussion today.
Yeah.
Your take, I think, regarding what we did in terms of granting immunity to businesses. I'm business oriented. I think that the overall net effect of that was we were going to be bailing businesses out. Everybody remembers, I have video when I was down on the Strip when there wasn't a single soul on
That
the
was
Strip
amazing.
but me, right? So you add to that the impetus for people who are out of work, don't have money, maybe sick because they have COVID or some other condition, and then filing a lawsuit, work comp claim, what have you, which is only going to hurt society as a large, at large, when you have those kinds of lawsuits. So, yeah, these are political decisions. I mean, politics is the art of the possible. It is also the way in which we organize people in a civilized society. We can do law of the jungle, survival of the fittest. Most people don't know where they're going to be on that totem pole. It isn't going to be pretty, right? So humans need to kind of remember that we're the most dangerous animal on the planet, and it's best for us to be civilized and do things that make sense so that we don't have civil collapse. That's what government is about, and that's what these decisions are about. So I firmly believe that it was the absolutely right thing to make sure that we didn't have a bunch of lawsuits about COVID. I think that, again, with regard to workers' comp particularly, unless you could trace your exposure to an exposure that arose out of your employment, the right decision was for those claims to be denied. COVID effectively was a communicable disease. We're not going to cover you for a cold. It was a severe cold in some cases. People have different opinions even about that. However, the question presented was, do we want this to be something that we treat as part of a workers' compensation system? And what the conclusion was, and I believe it was the right one, only for those first responders, other folks who, as a result of their job, came into contact with that virus and therefore were under the control of their employment as a result of that exposure, resulting in that exposure. That's how we did it. Was there a question? No? Okay. So I think that, yes, your point, Kevin, is correct. You and I are, we have similar roles. We have an adversarial legal system. I take this for what it's worth. I've never needed to figure out whether I wanted to do criminal law or plaintiff side work, whether it be claims or general liability or work comp, because of 2 things. Criminal law, we need people to do that, thank goodness for Kevin.
Thank God.
I am not a bleeding heart enough to want to save somebody who's found themselves in that situation. You were there because you did something that put you there. Your problem, not mine. Nor am I judgmental enough to want to sit in judgment as a prosecutor over somebody for mistakes that they've made. Not for me. I don't need to dabble in it. And on the other side, I don't like whining. I don't want to hear it. Life happened to you. It happens to all of us. I am a defense-oriented guy by design. This is what
Civil
I was made
defense,
to do.
obviously. Yeah.
Correct.
He
Not
says all that, and
criminal.
then he's like, "I'm a defense guy." I'm like, "You just
Not
bashed
criminal.
criminal defense."
Not-
Yeah.
It's clear. It's criminal. I don't even think about it.
Well, that's
It's-
most, yeah.
It's not for me. But that's the way. So I have a bias. I have a viewpoint on life. But ethics is broader than that. Ethics, again, like politics. I don't remember the Latin for ethics. However, ethics is the art of global kind of fairness, like what makes sense. It's a deep all of these are from deep philosophical traditions, right? About how do we organize ourselves in a way that helps us human beings stay civil and not murder each other, right? And so we have to have some rules, some logic, some reason as to why we do the things the way we do them. But everyone is going to see it through their own biases, call it a scotoma, which is tunnel vision. You have your own way of looking at life. The question is what you're doing appropriate for the greater good?
And I think that you really need to think about the moral standards and values. Because, again, not a judge. However, if you have survived in this earth, you understand where you stand on your moral compass. Because you have been ostracized, you've been whatever. So you know where your moral compass is. If your moral compass is diabolical and evil, then you need to take exceptions to your decisions when it comes to ethics. And that's because when I find people who are unethical, I find that foundationally they have very poor morals and they're diabolical. And so when you think about your ethics as an adjuster, a young adjuster a lot of times has more morals and value than an older adjuster who's been beat and understands that, I'm going to screw you before you screw me. And when you get into those feelings, and with ethics, I believe it has a lot to do with feelings. I mean, it's doing the right thing. And if you're not someone who does the right thing all the time, again, not judging you, you're probably one of my best friends, but I'm just saying that what you need to do is take a moment when you're making serious critical decisions about workers' comp and what you're doing. Are you doing it based on the rules, or are you doing it based on your personal morals and values? Are you mad at that person because they have colored hair? Are you whatever? Because if something else is coming into place, you're ethically being challenged. And regretfully, that's where I see my peers fail.
Well, so what Ann was just talking about is essentially self-regulation on your end. Now, attorneys, of course, we self-regulate, if you will, because the bar does that. But, one of the things, so I don't know how effective, and again, I don't know because I don't represent adjusters and I'm not in that world. I don't know how ethical regulation works in the adjuster world. That's, we're going to talk about some topics today. Dalton knows way more about that. But where you have ethical regulation, one of the things is that you think, well, so you're going to self-regulate. If she's talking about self-regulating, nothing wrong with that. I don't know how effective that will be because
It's a challenge,
you're talking to yourself and I'm doing the right thing. Yes, I am. No, I'm not. But no, but it's more
That's more of
extensive
a
than
you
that.
thing.
Yeah. And it's more extensive than that because where I remember when I was an intern at the Public Defender's Office in San Diego, the attorneys they said that it's not like everybody makes mistakes, and that's the thing too, is that some mistakes, if you make them, can actually be unethical, and cross over kind of in our world, and certainly in yours. But everybody can make mistakes. Okay, people aren't perfect. You can blow deadlines. You can do all kinds of things that, yes, are you could say, is that unethical? Sure. Okay. But it is so that is all gonna happen. It's the covering it up that's the problem, and that becomes really unethical, okay? So sometimes people equate, and I think this is more on, I mean, this can happen, I don't know about you, you can speak on your own behalf, but like on my end, like, have I worked at, a PI law firm or what have you, there's one statute of limitations, well, if for whatever reason that statute of limitations is blown, and that's what I'm saying, is that law firms can make mistakes. And so then, yes, the bar regulates that, because what is the bar regulating? Your ethical obligations, okay? So, but that doesn't mean all mistakes are unethical. I mean, so it does become into a really, really gray area. But if you're covering something up ever, you are wrong. I mean, that should be the flashing lights to you saying right now that you're not, that you're unethical, because why would you need to do that? You know?
Yeah, I think,
That's a heavy sentence.
so I think what Kevin, part of what you're saying is kind of in response to Ann, and I agree to the extent that Ann says, well, the worst actors, these are people who I think morally at their core have issues, and they're willing to skirt the law and that kind of thing. And there's certainly people out there like that. But in terms of ethical violations and rules, a lot of it can just be a simple mistake. An example of that, and it doesn't mean you're trying to do something bad. An example of that was when I was in law school. I was in my first clients were a couple of kids. I was in a child welfare clinic as a class. You get early admission to the bar to work as a lawyer on these files. So you've got real people's lives in your hands, and you're doing real law, and this family law, in my case. The kids wanted to be emancipated from their mother, who was, in and out of drugs, lots of problems. And so we took on their representation in the clinic, and one day I was in the clinic working on some stuff, and I was the only one there. Phone rang, I answered the phone, and it happened to be the kid's mom. And she wanted to know when the next hearing was. I answered that question for her. About 30 minutes later, her lawyer called up, losing his absolute mind that I spoke with a represented party, which you cannot do. And the way that we operate in workers' comp is foreign to the general practice of law. You can't call my client ever. It ain't rule number one, but it's in the top 5 that will get you into real trouble. So it became a real problem that I had taken this call. Again, I'd been a lawyer, a provisional lawyer, all about a week.
Oh, God.
And I just answered a phone call. And it didn't even occur to me. Now look, in the grand scheme of things, I shouldn't have taken the call. What I should have said, but that's, to me, is rude. Like, it doesn't seem ethical. Somebody's asking a simple question about a date. We're talking about how we're going to settle this case, lady. And I'll get to an example. I'll probably save that for later, where that did happen in my practice. Since I've been a lawyer, not by me, but somebody else, and it was a very interesting situation. But here, I'm not amoral. I'm just trying to be helpful and answer a simple question, but there are rules that are there to protect from this type of contact so that I don't go past the line, right? So every ethical violation is, Kevin is correct, it's not going to be it's not necessarily going to be an intentional wrongdoing, but it is a wrongdoing, and the rule is there to protect against greater harm from somebody who might cross that line and say, the best thing for your kids would really be for you to go away. Don't you think?
Right, yeah. Yeah.
Right.
The court date changed.
Oh, yeah. It's November 15th.
Yeah, yeah.
11th of Nontober at 11. Be there. right? So that is why the rules are there, but, this,
So how should you have handled that?
I should
Wait,
have
you have
said,
to ask the question
I'm
on the
sorry.
microphone.
Then I can't talk to you.
Correct.
Yeah.
That's the question you should have said.
Mhm.
I had
Well-
answered the question before I realized who she was. But yes, correct. The correct response, Mrs. Jones, we represent the other side. You have an attorney. I can't talk. You're going to need to speak with him about that and get off the phone as soon as possible. And so I still have a strong aversion of talking to somebody, even if they're not represented. I don't like talking to injured workers. If I don't have to, I'm not going to. And so we have lots of situations where we want to resolve things, and often you ladies that do this and men who do this will know that what we'll be wanting to have is ideally we want a lawyer on the other side. There's several reasons for that, not just because if they're not represented, there's no problem. The problem comes in where the legal system looks at an unrepresented party as being less sophisticated than me or Kevin. Whether that's true or not is a different thing. Undue influence is the term that's assigned to this, and the idea is that because we know all these lawyer Jedi mind tricks, we're going to trick them in doing something that they wouldn't otherwise do, right? So it's fraught with problems. I can enter into a perfectly good settlement with an injured worker and have it completely undone by somebody subsequently making an argument. Yeah, Dalton bamboozled this poor lady, and she should have gotten a lot more benefits, so that settlement is null and void. I've never seen it happen in workers' comp, but it certainly can. And it does happen in other areas of the law all the time. So this slide, go ahead.
I think that's critical in the sense that adjusters, when you pick that phone up and it's Mr. Smith, who you know is represented, you can't go forward. You can say to them, hey, what's going, okay, tell you what, you need to call your attorney. I'll call your attorney or something like that. I see my adjusters, not my current adjusters, but I've seen adjusters get into trouble trying to be nice and help when in fact they're not.
Well, and similarly, okay, I had seen where adjusters trying to be helpful, my staff are trying to be helpful as well, and those are the ones that are communicating, and it's not with me.
Right.
And so everybody's trying to do the right thing, and they probably are, even for the injured worker. However, each one of them has a lawyer, okay, and that is unethical. It's interesting you talk about the opposing counsel, is that Dalton is correct, is that it is a very unique, we'll call it that, area of law. I'm glad we have electronic filing now, and that's taken us kind of, into the next generation. But what I'll tell you is this, sometimes people wonder, and this is where their own personal, and it's really just ignorance, I'm not saying in a bad way, but just not knowing what my ethical obligations are on my end and and how I conduct myself as a lawyer. They just don't understand that. Well, you don't need to, and especially as a non-lawyer, or even as a lawyer, you don't need to know that. But so he just let me share an experience, okay, of sometimes like Sean always makes a point where back in the day I used to share different experiences. Remember before the Gilman case? Remember, we felt like we had to appeal every single claim acceptance to preserve rights and all of that. Well, some people disagreed with that. Well, great, okay, then, but if I'm representing people, that's what I do. Then the law changed and that went away. But prior to that, I shared that, in the very beginning of, look, this is why Kevin Campshire and Shook 'em Stone at the time, appeals claimed acceptance. It's because of my ethical obligation with my client and all of that. Okay, so people don't understand that. But there's a scenario where, and this is just unfortunate, and there was no intent behind any of it, and it still was unethical, and I can see it happening to anyone, is where, and that's why I'm very particular. If you are at AO or even at HO and you've hired a lawyer, do not contact my office. Do not. And don't have an attitude if I don't talk to you, or if I don't return your email or whatever. You hired a lawyer, and guess what? I respect them, okay, and we get into respect here and all that, but my ethical obligation is I'm not going to talk to a represented person, and I know they're represented. I'm not going to do it. It has nothing to do with you. So, but, I've had people, again, trying to help, where it wasn't us, okay? But in our world, an attorney had reached out wanting to find out, I don't remember, it's like, who was the TPA or something like that. Trying to find out who the defense counsel was. I don't remember the exact facts. I mean, it went through the bar, so it's public record, okay? But, okay, and one of the attorneys lost it, that they were, because it was to the adjuster, people were CC'd. That's what I'm talking about. Your CCing doesn't somehow give you some sort of approval to talk to people, okay? Like if you have a case with Dalton, and it's an AO, and you reach out to me to talk to me about something about that case and CC Dalton, no, okay, I'm not gonna talk to you. That is unethical for you to go around him, okay, and do that. And I get it, you're trying to be helpful, so it's not like you're doing anything vindictive. But long story short, this attorney unfortunately filed a bar complaint against the other attorney, okay, and it's in our world. I'm sure there have been, others, but that is one thing that I have always kind of appreciated. Well, first of all, we're ethical people, but like, I would never, I'll share a story where I almost had to go to the bar with a lawyer, and we'll get into that lawyers can accept cases. They have to be competent, meaning they have to know what they're doing to accept them. And we do get, and I'm sure you see them, kind of these random lawyers sometimes that kind of dip in and do whatever, and they have to know what they're doing, and they can't, if they don't know what they're doing, they can't go in and tell the court, something wrong. But long story short, that people don't know stuff like that. And so all they see is that I'm trying to communicate with Kevin, and he's not communicating with me. What an asshole. No, that's not that. Here's all the context, okay? And I live by all that type of stuff because you gotta do the right thing. We worked hard, and I don't disrespect the people I work with, which is generally the attorneys, so.
And I think that the injured workers don't understand the dynamics between everybody, and
Oh,
that's,
no.
and they're already in a situation that is an extreme high stress level. And on their side, every once in a while you come across one that maybe isn't so upfront also.
Well, we have further problems, and that is the way we do it in workers' comp is not the way it's done, right? So we have what has become, what we have is what's become an industry practice, kind of a local rule is what lawyers would call that. The way that folks have been doing this since NIC have decided to do it to address the realities. And that is, there are several ways that we could decide whether Ann is represented by an attorney.
Like date week.
Well, no, so what we have decided, and Kevin pointed out, is if you're in litigation at an HO or an AO, then you're in litigation and you're represented. However, that isn't really how it works in a lot of situations. It is, I am your counsel, we do workers' comp matters, and workers' comp matters you're represented, they need to go through me, period, in a discussion. That would make it functionally impossible to do the work that we need to do. I'm not adjusting claims, right? So one feature of the ethical rules, Kevin has mentioned our rules, the lawyers, we get ethics in law school. You have to do an ethical exam as part of a separate test from the bar examination, which is legal knowledge and content. You also have to take an ethics exam and pass both of those. On that ethics exam,
Those questions.
the MPRE, he's laughing because everybody kind of knows this. If you craft a multiple choice question properly, and these are done that way, they are the hardest test you will take. Much harder than an essay or something where you can fill it out. The answers are going to be close, but not quite the same. You've got to spot the difference and understand the nuance, blah, blah, blah. Well, generally speaking, the answer on the MPRE, which is that ethics exam, is not the most ethical one. It's the second most ethical one, seemingly, if you're reading them in a vacuum. Because the rules for ethics are not there to preclude you from doing your job. If the rule is do no harm, and I interpret that to mean I can't win a case against the other side, then I can't do my job. Because it is a harm to his client, potentially, if I win, correct? So that's not how ethics works. It has to be practical. It has to make sense. And so you're going to have a lot of gray. Back to my point, we don't treat it like Ann's in litigation all the time, and you always have to go through me or whatever attorney is representing her, because then nothing would get done. But because it's gray, because this is something that has developed because of practice and habit, the rules aren't clear. And people who are new to this, who step into it, sometimes run afoul of those, and people have different opinions within our industry. Certainly, if you're in litigation on a claim denial, you're not talking to Kevin. Kevin is not going to reach out to you. He's going to hear from me, and it ain't going to be a good phone call. I'm probably not going to refer Kevin to the bar. So far, so good. However, that is certainly one of the options that's available to me. We can talk about later what the bar would do with that. However, that is a clear, bright line. There's only one thing going on. There's no claim that's being administered. There's no reason that you need to be talking to my client except for to do something nefarious. Or it's going to be presumed that you are just because you're making the call. If, however, we're on an accepted claim and we're litigating denial of travel reimbursement, I have the opinion, most of us, I believe, have the opinion that it's perfectly fine for Kevin to talk to you about anything but that. But that would never happen in any other area of law. That contact is forbidden, right? So we have weird rules that aren't written down that create the potential for conflict when people don't agree on what the nature of it was. I'll go ahead and give the example that I was going to give earlier. And it was, I was representing somebody who's now retired from the industry, and she had denied a claim, and the case was in litigation. We got past that point. We had a couple of issues with regard to TTD and PPD and a couple of other things. Those were part of the litigation because the whole case was up. Opposing counsel calls me one day and says, hey, this case is settled. I have an email between my assistant and yours where your client basically agreed to these terms. And I said, well, that's going to kind of be a problem. And he decided that after I said absolutely not, that first of all, your interpretation of what this communication is incorrect. And also, pound sand, not happening. So he decides, foolishly, that in order to enforce this agreement, that he is going to demand to depose my client. I believe Michelle Magando was the judge, and she allowed the deposition to go forward, because she allowed a lot of things to go forward that probably shouldn't. It's fine. So
Except the running of the administration, but that's okay. Yeah, no.
oh, ouch.
Different.
Yikes. Wow. She's not here to defend herself, Kevin. Anyhow, so we set up the deposition. We go over to his office. He's now deposing my client. And I remind him, you do understand that when you depose my client and you have her testify that she spoke with your office manager to accept this settlement proposal the whole time while I was representing her, that what I'm going to do is take that transcript and send it over to the bar, because you have the unauthorized practice of law. You are negotiating with a represented party. Is this really what you want to do? Took him a little while to figure it out. But we got there, and we got the case done without that turning into the most ridiculous self-inflicted wound in the history of mankind. So this can get fairly egregious. You can get out over your skis. But again, in terms of just kind of getting back to the slides, because we're not really going to go through.
I'm sorry, can I ask a question? Because I want to see, now I can't see people online, but just people sitting here. Because, and I mean, again, you don't have to have the right or wrong answer, but I want to see what people think. I saw, like the example I gave about adjusters talking to my staff about stuff, you know, and maybe it's the resolution that we were going to come up with, like, I don't know what it is, but, you know, so either client called adjuster or even say, you know, represented injured worker contacts the adjuster, okay, and a conversation is had or what have you, or, you're all talking with my staff, or, some scenario like that, okay? Does anybody think that the originator of the communication, like, it's like, well, who's the one ethical? Do you think just both are unethical, or do you think that the person who actually reached out actually bears the burden of the ethics?
Are we calling ignorance bliss? 'Cause
No, I just want to,
otherwise
I want to know, because I'm going to make a point.
Both.
Okay, yeah, no, it doesn't matter who contacts who does first, okay, anything like that. I mean, because Dalton just shared the example of when he, was in law school, they contacted, that person contacted him, okay? Now, that probably, would you certainly, if that actually rose to some sort of complaint, I mean, certainly in your response, you would say that, be like, well, look, again, you made a mistake. Someone contacts us. I mean, you're assuming that other, adverse parties don't contact you. You're just assuming, and all they asked for was a court date, which, by the way, isn't a breach of confidentiality. So it's not even that you've disclosed, you're gonna be like, well, here's the address, here's the money, here's the financial disclosures, all of that. Like, none of that happened. So yeah, that would be a response, but that just demonstrates that ethics, though, doesn't really care about any of that. About who is the instigator, I guess, is if you want to frame it like that. So
Yeah, and to add another level of confusion to this, because again, ethics it's really not black and white. There are some things where there are bright lines, but in general liability litigation, the rules for lawyers communicating with represented parties are ethical rules for lawyers. They do not apply to the litigants. If the litigants on their own, if it's Jane versus Bob and this is a dispute about a contract and they decide without their lawyers that they're going to get together and they reach out to one another and talk to each other and settle it, there's no ethical violation there. They can do whatever they want to. They've hired lawyers. The ethical rules are there to protect their interests from lawyers doing things that violate our code. Those don't apply to the parties. So the injured worker can reach out to Anne. The problem is Anne does have ethical obligations. They're not the same as lawyers. They're similar. They're in the same vein. But she does have those, let's call them handcuffs, right? So she's handcuffed. They are not. And that does make it difficult sometimes because, again, you want to be helpful. And then, again, add more gray to it. Are they calling about this issue of voc rehab, or are they calling about they need their scripts? Is Kevin going to be upset if Anne takes a call and helps the claimant get her medication, even though we're litigating something else? Probably not. But could he? Absolutely. And that is where this becomes an art. The attorney in my family, in my case with my kids who were emancipated, we got what we wanted out of that case. Yeah, I'm a kid in school. This is a nothing burger, but he made a federal case out of it because the rule says you cannot have contact with a represented party. He's absolutely right. As Kevin said, there's no harm, there's no foul, except for the violation of the rule, which he wanted to send a message to the clinic. That's fine. It was not a big deal. It didn't harm me at all. We got over it because it was really nothing. However, that forbearance is a decision, right? And we are making forbearance decisions every day in workers' comp in terms of what is okay, what's across the line, what isn't. And it's very much in flux and gray. And
my question on that is the sin of omission. And
what did you say?
The sin of omission.
Oh, okay.
What I find is I'll hear an adjuster talking, but leaving out critical parts of the conversation.
Yeah.
My feeling is that's ethically wrong.
Why do you feel that way?
Because you're hiding information that benefits them and hurts you, usually. In this situation in workers' comp, they're not disclosing benefits that are available or how to get those benefits. When you said that about travel, a lot of people don't understand it. And can I get paid going back and forth? I hear the answer to that being so abstract, and it's not. 40 miles, you know, et cetera. So I think the sin of omission is part of an unethical decision an adjuster makes.
So why then, just a follow-up to this, is that why, I mean, you may not know because you're not in the minds of these people, but in that particular scenario, why do you think the adjuster did that?
They want to hold the upper hand. I know, it's terrible, and I hate to say it
The
like that.
upper hand of?
I got information you ain't got.
Oh.
I got
At
information
the expense of?
of not providing benefits.
No, of a person that was
Right.
injured, yeah,
Right,
yeah.
and
Huh.
that's, I think the sin of omission, sometimes people don't say it for various reasons that they justify in their mind. The screen before this one, I think, is critical, because those are the things you need to do. You need to be honest. You need to, and if you can't tell them, then simply say, you know what, I'm not able to discuss that with you, whatever that would be, I don't even know, because you all know I talk about too much. Integrity, you know, you have to do it without regards to the consequences. I told you what is true, despite the fact that you're gonna get more benefits, or I'm gonna be in trouble for not doing something. Responsibility, honoring the promises and commitments, not yours. We're not talking about a marriage contract, we're talking about the job. We're talking about the fact you took a job as an adjuster, and you are now responsible for administrating the act. And that's exactly what you need, that's your responsibility. Respect, treat people right. I don't care if they have 42 claims. I happen to have one right now that does have 42 claims, but it doesn't matter. And regardless of what that person does and why they have 42 claims, I still have to respect them when they call me with the absurdities that they do.
I don't know why we're hiding the information. When I was a claims manager, my claims package included a mileage form and the mileage information.
Ours does
I
too.
come with my employees come to me and all they have is a med release. That's all I want to know is you're pre-existing. There's a lot of information that's required to go out to these employees, and why are we hiding it?
That's exactly right. That's exactly right.
So that's a
Single mission.
perfect segue into, hold on one second, that's a perfect segue. You remember where we left off last time, those of you who joined us last time, we kind of started to talk about that, it was about unauthorized practice of law. And what we were really talking about is specifically adjusters' communication with unrepresented people, because, you know, not that you wouldn't send the same letter if that person's represented, but you're CCing me, you're doing what have you. And he and I have had many conversations about this kind of over the years, but it was, if you recall, when Sean and I were talking about it, and then people had a lot of questions about things, about how do you say this, why do you not say that, what's more appropriate for them, like, and how do you get out of the unauthorized practice of law, remembering it's not like there's a penalty, like you don't have the hall monitor coming and giving you a check mark, or DIR coming and doing something because you did the unauthorized practice of law. No, but obviously it is a felony. I don't think the DA's office is going to come and charge you with a felony in regards to a communication with an injured worker, but you never know. But it just means that you can be unaware of the unauthorized practice of law, and that is exactly how you're saying, how you're wording things. So, Christy, do you have a question before we get into that? But Sandy, because I found it fascinating, and if you all recall, like Sean, I was like, yes, I agree with you, Sean. Yes, I agree with you, Sean. Yes, I agree with you, Sean. Because it was about, it was just, again, not substance ethics, how you represent an adjuster, that's on them. But just from what he was saying, I agreed as a lawyer of what he was saying in regards to, what was unauthorized and what wasn't.
The other thing that I never allowed my adjusters to do with an unrepresented injured worker was to give them the 3 physicians for the PPD. It's not unethical to do it, it's not illegal to do it, it's well within our rights, but it's the perception. So I never wanted an employee to come back and say, wow, you picked 3 doctors that you thought were the best, instead of just letting the DIR assign a random one. So that was just a business practice in my claims office. I didn't want that perception that somehow we had our hand on the scale of your PPD evaluation.
So that's interesting. I mean, and she's right. There's nothing unethical about that. You, as a business or as an insurer or TPA or what have you, if you decide that you are, if that is the concern about perception and all of that, I mean, yeah, I think that does fall under ethics.
Christy, did somebody
Yeah.
have a question online, or what was it?
No, so that an ethical obligation, like if you omit records for certain cases because you don't want them to see them, or?
Who are you omitting
Oh,
them
hold on.
to? Like, where are you sending them, I guess would be my
Like to a
question.
doctor for an IME.
Oh,
Like you
well, I
see
mean,
all-
Like, so you have a case from 2018, but then there's only 44 records, so like, where's the rest of them? Is that an ethical obligation for the adjuster to obviously provide all of the
Well,
records?
was it litigated during that time? So they don't
Yeah,
have records?
and maybe there's a prior IME that says, I reviewed 4,000 records and I get 400. Where's the other?
Yeah.
30?
well, now, the question
It's
which,
lost in the mountain.
now, I mean, the question that we'll get into is I'd like to see, find out what people's opinions are, but you just added to it, Corey just added to it, then Trish just added to it. So that we have the question here in regards to what's the ethical obligation, then you asked about some litigation, okay, and then you asked about something about 400 versus 4,000, getting back to, all right, so doctor did an evaluation and did not have all of the records, and is that unethical? I mean, now I would want to ask, I have to ask more questions. I mean, then it goes back to, okay, did you do it on purpose? I mean, was this a scenario where adjuster is working from home, assistants in the office, someone else is in charge of actually physically sending records, and something actually legitimately happened? Like, you know, because then, is that necessarily unethical if something like that happens?
So I think
What
this
do you
goes back to
think?
Ann's point about omission. So the rules don't care whether your lack of, so for lawyers, this is under the ethical obligations as a duty of candor to the court, to opposing counsel, to the parties, right? So candor is about being truthful. Whether you omit a fact or intentionally lie, it's not being candid, right? So that's the rule. It's tell the truth. And that's included in the scenario that Christy has raised in terms of providing documents in the context of an IME. We'll just limit it to that. Corey is absolutely right. If it's a file that's in litigation because it's claim denial, well, she's not going to be able to provide records that she doesn't have on a claim that she's not administering, right?
And on that, when we ask the plaintiff attorney for records, they don't send it to us.
But they give them to the PPD doctor.
Finish my sentence. Yeah, so, perfect example, so that's why I said, when it's in litigation, we don't have all the records, the providers are no longer billing us. Then when we ask the plaintiff attorneys for the records, or even for their prior claim that they're also representing, that they're trying to argue subsequent injury for, they won't provide us with those records. So these IMEs are incomplete because we don't have all the records, either from the carrier side or both sides.
Sure.
So then my response to you is then no, you personally are not being unethical in that scenario, because we're talking about ethics.
Right,
Yeah.
so you can't provide records that you don't have.
All right.
The issue is, under those circumstances, there's more to administration of claims than just the
Bit too much, huh, Sandy?
ethical administration of them. We also have the efficient administration of them, right? So it's not helpful to be spending a bunch of time spinning wheels trying to get records, trying to get an IME when we don't have the records. That's why we have to kind of work together to make sure that we do that, but that certainly happens.
I'm gonna say also, and it's hard, it's a gray area. Part of the problem with those IMEs and that is if I give you the 4,000 and instead of the 400, it costs me $15,000 or $25,000. The fiduciary responsibility to be able to justify that is crazy. So as an administrator, what I do, and I'm gonna say it in public, is I do go through those and I provide the records that are relevant and appropriate. So the question then is, who am I to make those decisions? How do I get to say, hey, that's appropriate or that's not appropriate? So I do think that's a foundational problem, because I will send you 400 pages as opposed to 4,000, because I don't know a single IME doctor in town that is worth $10,000.
Well, if I'm representing you on that file and we're in litigation, it's gonna be pretty simple. I'm going to ask you to Bate stamped the pages that you sent so that we have that attached to documents, so we have it to opposing counsel so that they know what was sent. Presumably, if you're doing the job, it is not to simply take a pile of paper and send it to the doctor. We have a medical question that we're asking the doctor to ask. You're going to provide the medical records. You are, for economic reasons, time reasons, going to want to omit duplicates. In that process, mistakes happen. If Kevin knows I sent 400 pages, they're numbered 1 through 400. If there's something that he thinks there should be in there, or Javier or anybody else, they know what you sent, and everything is above board, perfectly ethical. Mistakes are going to happen. A mistake may also present as an ethical violation, but an intentional act to omit something that, I mean, that's not a gray line. Everybody understands that you're trying to get over, and you're probably not going to.
And then there's layers of ethical violation. So let's say it's let's put one more layer to it. Okay, same scenario. Let's say it's ordered under NRS 616C360, which is by the appeals officer. Say there's an IME ordered. So then we have to. There's an ethical layer in regards to. Say my office. Sometimes I have done this. I haven't done it recently, but I have sent my own packet of medical records. Okay, if it was, say, I don't know if I've done it on a 360, but nonetheless, I've sent it. But the point being, I have to copy them on what I'm sending to the doctor. Okay, that isn't, that's ethical. I do want to actually ask this because again, not my world, but do you believe? When you're talking about cost, okay, so obviously there's like no one's working for free. When doctors do IMEs, or even if it's a treating physician or what have you, but I think I see it more on IMEs. Is it an ethical violation of the adjuster that is actually, because they hold the purse, right? Well, if that doctor hasn't been paid, and then thereafter some of them withhold the report, so then no one can do anything. I just would love to find out what the consensus is in regards to what does the adjuster believe, if any, or what ethical violation they have in regards to payment, if any, in that type of scenario.
I got an opinion.
What is it?
Regulation states that I cannot pay a bill without a report.
That's correct.
So,
Chicken or egg, the report comes first,
Okay,
then
so what
payment.
if the report was given and it's still past the 45 days legally by law? but
that's
it's
what I
still-
think needs to be fixed. Because I deal with you guys all the time with regards to the lack of payment. And I hear the doctors so often saying, yeah, I got AP, 2 years old. That is absurd.
400,000.
Yeah, that's absurd. And that, Jason, if you're listening, needs to be fixed.
So,
Because we need to, just because
You mean
that's
NJA? Oh, we're gonna.
so listen,
That's not what we're here for. That we have to fix your
But
doctors
that's-
getting paid.
Not getting paid is huge, and that in fact is a reality of what's happening in our
it is huge, but it
Yeah.
neither is nor should be an ethical issue. And if it is one, it isn't one for the adjuster.
Really?
It is one for the doctor. Because,
Why would it be a doctor?
listen to me. The report, when you decide that you're going to be on that panel and treat workers' compensation patients, and you receive and decide that you're going to do an IME, the report is due when you're done with it. You don't get paid
So
until,
what if you
let me
didn't?
finish. You don't get paid until you send the report. So you don't have an ability to inconvenience or otherwise harm the injured worker. You have taken on this responsibility and this decision. That's it. There's not an ethical problem
Sure.
there. The issue between the adjuster, to the extent that there's a payment problem and the report has been sent and you've done all of those things, it is a problem. Certainly, everybody, you guys were joking about when you said nobody's working for free. Yeah, it just feels like it sometimes. But certainly, doctors aren't going to stay on the panel. They aren't going to continue to do work for workers' comp, and it's one of the reasons that we have problems with them now. But that is a separate, and we're talking about ethics here. The question isn't, is it unethical for a claims adjuster to not pay a doctor timely.
Oh, that is my question. Oh,
That is-
oh,
In
oh,
terms-
oh, oh, no.
In terms,
Oh, oh.
in terms of the claimant. The
Oh, oh,
doctor
oh, oh.
does not have the ability, because he is unpaid, to harm the claimant. This is a separate question, and in
So
fact,
is it an ethical issue for the adjuster, the third party, or the TPA to have the report, have the HICPA, and not pay the bill?
No, it's not ethical.
It's against the law.
well,
It's against the statute?
no, I think it is ethical. It is an ethical issue that's
Against
outside of the
who?
scope of the claim.
Against who though?
It is a problem to take work, have to assign work to somebody and not pay them to do it, right?
For who though, specifically?
Take the work product and use it.
It's not the adjuster, because the adjuster doesn't have the ability to write the check or have a checkbook necessarily.
Correct. So
then that
to
would
the
be
extent that a
TPA.
doctor is having a problem with an entity that isn't paying him timely, that's a problem with the entity. And what that is, ultimately, is a contract dispute. You're not going to get that resolved in the workers' comp system. An appeals officer is never going to hear that. If you're gonna have an ongoing problem with it, you're gonna solve that one or two ways. You're gonna disassociate yourself from doing business with that entity. And if you can't get it resolved, you're going to sue them in district court. It's not a work comp issue. You're gonna sue them in workers' comp, you're gonna sue them outside of our system,
Yeah.
right? Our system is already
Services
designed
rendered, yeah.
with the protection for the person who matters.
So there's
The,
no
ec-
ethical obligation.
it is the efficient administration of claims. That's why
There's a
report doc,
legal obligation.
and then you get paid. Right, and so we have a lot of doctors who have tried to backfill that, which is why they're demanding, I don't even look at it until you send me all the reports. I'll look at the records and then I'll decide if I want to do this. If there've been too many doctors involved in this, if I'm the fifth opinion, I probably don't want to touch this because it's a mess. So there are structural problems that are created by this, and if we would just get people paid timely, but here's the deal. I've been around enough of these problems. It is frequently well, you sent me the report, but I don't actually have, you also have to submit a bill. That has to be coded properly, and that needs to go to the right place, and it's gotta go over to this one. And there are problems there, but they are outside of the scope of what an adjuster is doing day-to-day to administer a claim. So my answer to the question, is it unethical for the adjuster to not pay the doctor? Or the way you posed it was that, the doctor is holding up the report. Now, that's an ethical problem. The doctor getting paid is important.
Critical.
Us getting paid is important, but if Kevin is representing, we'll take it outside of the workers' comp realm, because that's done primarily contingency, so there isn't. But if he's representing somebody in a criminal case, in criminal cases, bring your checkbook, because guess what? I don't know about Kevin, he can speak for himself. If I'm a lawyer and I'm doing criminal defense, I don't trust you, you're a criminal. So you're gonna need to give me $25,000 or whatever it is that I think that I'm going to do. And when that retainer is gone, I'm not working because I know you ain't good for it, right? Kevin can't just jump out of the case and prejudice that person. Doctors have a Hippocratic oath. They can do no harm. So they can't hold up a work product that they've agreed to do.
Most of the time, we're not talking about a doctor holding up a
Microphone,
report.
microphone.
Most of the time, we're talking about.
Wait, start, people can hear you on the
We're not
microphone.
talking about doctors holding up reports, because most of the time they do.
That was the scenario that he
But
presented.
I'm
That was
just
what I
saying-
said.
So, but what I am saying is that a lot of times the doctors do the report, they do the HIPAA, they send it in, and they're not paid. So is there an ethical obligation from any of the entities, third-party bill pay, TPA, or adjuster, to pay that bill?
It is categorically unethical to retain somebody to do something, to enter into a contract, to hire somebody to do a job, not paying for it. Of course, that's unethical. But the ethics we're talking about are for adjusters in the scope of managing claims.
Legal.
There's no repercussions for
There's legal.
unethical practice.
Well, he talked about the repercussions. Are you talking about like ethical repercussions
Yes,
or like
ethical.
financial? No.
The way we deal with, look, contracts are about money. And so the way we deal with money issues is we take that to district court and we pay people damages, right? And if there's some egregious behavior, there's an opportunity to enhance those penalties. Bad faith, all kinds of things like that.
I
But
have won 2 benefit penalties filed against me for not paying the doctor first, because I refused to. And both times the claimant's attorney filed benefit penalties on me. DER went through, AO went through, no findings. Statute clearly says you have to have the report and the bill.
It's report and then bill. There's no other way about it. And again, it's a statutory creation. Again, outside of that, you not getting compensated for work that you've done, that's a job for Wapner.
That's our, he's talking about Judge Wapner. Oh, you know what?
Judy,
missed
I don't know
Judge
where
Judy.
this is.
Hey, yeah, Judge Judy, we Jews stick together. Okay, so wait, any more on any of that? I just have always asked that, and yes, it was specific because I have seen it where it's held up, where the doctor is like not releasing the report because they haven't been paid, and I'm like, what are you talking about? But, take that even a step further, is that, and I don't blame, like that's the whole thing, is that it is a very difficult position to be in representing that injured worker, because your recourse, they want it now, we're all waiting on the report, like it's not like anybody, but it's just a system that is not connecting. I'm sure there's a lot of finger pointing going on that I don't even know about, nor do I care. But then, we're waiting on this report. For all we know, we could be waiting on this report to make a decision of whether or not the case is going to go one way or the other. And one of the things about my ethical obligations are, my obviously, first and foremost is to my own clients. And when it comes time to delay and waiting and explaining, and it could be a perfectly good explanation, and I certainly have not built my success on not being able to communicate with injured workers. Okay, I do it very well. And so I can generally, with that, if that scenario were to come up, I'm not having them demanding, go to district court and do all of these things that Dalton is talking about, because it's called client control and you have to be able to. But that's not, some of those conversations take 1 minute, some of them take 15. And so, people just don't always, yes, I hate to, I think it's kind of a cliche to be like, these are real people here. Well, we all know that, but what is the impact, okay, if any, when something like this happens? And you can just see here, not paying a bill can, create significant issues for the injured worker. Back to our very beginning slide, remember, it's quick and efficient administration of benefits at a reasonable cost. That's not that.
Well, another way that this does play out that raises a different ethical issue for injured workers is when there are unpaid bills. Let's say the claim was initially denied, or in some cases maybe doctors are filing liens or coming after folks messing up their credit reports saying that they didn't pay these bills, where the obligation is this is an accepted claim, whether it was litigated because it was outside of the scope of the claim or, again, denied. We have several cases where, I don't know how many times you've done it, Kevin, but I certainly know that one of the things you have to deal with on your side is now you've got a client who, in addition to they don't have money, now they've got issues with their credit reports, and the statutes are very clear. If it's something that is ours, we are responsible to pay that back. The law says that the medical providers may not, under those circumstances, go after the injured worker. They do it all the time, as a matter of course. And so there's different ways that we deal with that. Oftentimes what I'll do is we'll get the judge issue a determination that expressly states what the law is. Then the injured worker has something they can send to the credit reporting agencies, but that's a lot of work, and it's tedious getting them to get those things off. So there are things that happen that are, broader problems in terms of the ethical, and they're all, Christy, to your point, these are all ethical issues. We're just trying to focus on those that directly impact adjusters in the administration of the claims, and getting those bills paid, absolutely important. But as you note, they're not cutting the check. If they've done what they're supposed to do, they've got the bill, they send it in, and it's not coming out, that's going to be a dispute between the doctor and the entity. These issues where the act is there primarily to protect and move forward these cases for the injured workers. And so that's why we have express laws that deal with consumer debt and these liens that folks will put on their credit, because that's something that we want to protect. We figure the doctors and other medical providers, lawyers, I'm not in there if I'm not getting paid, we can sort that out under a different chapter of the NRS on our own.
When I love that example that he gave about the bills, because we, as lawyers, do that, and again, take it a step further of see how many ethical obligations it just checks the box for. So these bills, right, they come out of nowhere, we get them, and there's no dispute about that they're covered under the claim, but nonetheless, the provider is still billing the injured worker, and maybe it's in collections, I mean, maybe it's not, okay? But so, now, is there anything that the hearing officer is going to be able to do? Well, no, I mean, is there any of us are gonna be able to do? They need to stop billing the injured worker, and none of us, like, outside of suing them, I mean, there's nothing like, it's a free country, okay? So they can do that, but how do we then navigate? How do I, make sure I cover my ethical obligations of the injured worker in that scenario? And how do we then not create, endless work for everyone to do that? So, like what he said is we come out, well, I don't want to say we, but I do this all the time, and I prefer it, is that, look, everybody's tried, but yet they're still being billed, okay? Well, that's not the TPA's problem, that's not my, but we still have that problem. So we get the HO, so that way we have a court order, okay? And so that will never come back on you or me or any of that. We did what we needed to do, okay? And you don't have a remand to just do what they've already done and to have this thing sitting out there and do all of that. So there is the efficiency there as well that does, cover all bases. Are we taking a small
Potty
break?
break. Yeah,
I was just
potty
gonna say, I'm like,
Potty break.
and with that,
Potty break. 15? 10.
15.
Yeah, 15.
Is that okay?
Quarter till,
10 minutes.
wherever you want to start. You tell me.
Okay, let's talk a little.
Uh,
Are we back on?
Yes, we're back on.
Okay, welcome back.
Isn't that what I need?
All right,
slides for it?
so, no, it was, it really is kind of under this.
Okay.
So, I love all the robust discussions, and you can say they move from topic to topic. Were you gonna say something?
No, it's still,
Oh.
my screen is on. Everything's good.
Yep.
Oh, and so you kind of weave in and out of topics, but again, remembering where we picked off last year, or not last year, feels like last year, when Sean and I were here, and we really talked a lot about the unauthorized practice of law and its communication to injured workers, really from adjuster to injured worker. We talked mostly, I think they talked mostly about unrepresented people, but I think that people had a lot of questions about, so for example, reopening, I think was what we talked about.
Since I wasn't here, can we back up? Can you define what the unauthorized practice of law is?
Can I? No, because I never do it.
Well, you're authorized. Well, you're authorized.
Yeah, yeah. I don't know, there is a legal definition. Do you know it? Is that why you
And,
asked?
no, I
Oh.
did it because I want to kind of set the stage for what it is. I mean, go
It's
ahead.
huge. It's huge, because that's one of the, it's so big. And the reason I say it that way is because as adjusters, the two things that we become are attorneys and doctors, because we've got Google, duh. And so, as a result of that, sometimes we speak because we've seen it so many times and we're so old that we understand it. You still can't cross that line. I can't talk to an adjuster about how that meniscus repair is going to heal and how they're going to feel and all the things that take care, as well as I cannot discuss to them the extent of the law. I can't explain the law to them. I can't tell them that law, even though I have heard thousands of adjusters talking legalese. And that is where the issues really develop.
So, Ann, I think that's really good. To Kevin's point, I think the unauthorized practice of law is like the Supreme Court said many years ago about pornography. You know it when you see it.
That's true.
But here's the reality. First of all, let's talk about why we have it. Unauthorized practice of law is something that bar organizations across the nation enforce and regulate. So it is an attempt to regulate what and who constitutes the practice of law, or constitutes a lawyer, or the practice of law. Most recently, Ann mentioned that you guys have Google. You've got more than that. Tomorrow I'll be, I guess, here again for NSIA, and we'll be talking about AI and workers' comp.
Do you want me to read Google's definition?
No.
I don't,
Okay.
but so you have more than Google. You have ChatGPT, you've got Claude, you've got all of these AI tools that you can use, and you might get something that looks like some good legal advice. Now, there was a case that came out I'll talk a lot about this tomorrow in that presentation, but there's a case that came out just a couple of days ago in Chicago, where the Supreme Court of Chicago has found that the AI assistant that was being used by the litigant was committing the unauthorized practice of law. Because an AI is not a lawyer. It does not have a law license, it has no ethical obligations, and it cannot practice law. So, practicing law typically is defined as providing legal advice or representation. So, a corporation, a company, can only be represented by a lawyer. A person cannot represent a company.
Real quick, hold on, can everybody hear online? Okay,
Are we good?
yes.
Okay.
I think it was when we were on the break. Okay,
So,
we're good.
if you a non-lawyer decided that you were going to go into a work comp case and represent CCMSI or some other entity, you can't do it. Only a lawyer can do that. If you're providing legal advice, this is what you should do. These are your rights. That is practicing law. And unless you have a license from the state of Nevada, you can't do that in this state. So that's what we're talking about. We're talking about crossing a line that is there. It is protectionist, to be sure. People think that it's the bar protecting the profession to keep other people from cutting into our racket. The bar believes that what they're doing is protecting the public from incompetence. We are rigorously tested in order to get our licenses. We have to go through the undergrad, you gotta do law school. We get the ethical obligations, and then the bar checks our character and fitness and decides whether we're worthy of holding the title. They guard it carefully, and they don't want, the concern is that if, this is kind of funny, the concern is they don't want lawyers to have bad reputation. And they don't want people to get harmed by somebody who's either incompetent or unethical, not properly trained, and doesn't understand the rules. That's what this is all about. So we are in a world where you're going to see this issue with AI. How is this going to play out as it goes forward? As a tool, even as a tool for individuals to use in court on their own, people have run into problems with that because you can't bring in a courtroom, you can't have devices that are connected to the internet, your phone, and talking back and forth. That doesn't work. So people have tried to go in pro se and use that ChatGPT to litigate because they don't want to hire a lawyer. And they've run afoul of these rules. So in our context, what is providing advice versus adjusting the claim? Anne mentioned earlier, and I flagged it, I wanted to bring it back up, that she has concerns about adjusters who are omitting things that are potentially a right that the claimant has. Well, there's a line there too. You're presenting what you think they're entitled to under the Act, which Kevin may have a different opinion about what his client is entitled to under the Act. And so there's a very, very fine, almost indefinable line in some cases between I'm doing my job as an adjuster, adjusting this claim under the Act, versus providing advice. In my mind, the line is where somebody is going to rely on what you've said in such a way that if you're wrong, they can be harmed. You've provided legal advice at that point. We have it happen all the time in the system. It's not just you adjusters. At the HO, we've had routinely in the past, I've personally called it out, talked with Dean and others about it, and I know there's been an effort to curb it. Hearings officers explaining to claimants during the hearing what they can, what they can't do, what they should do. That's providing
Hearing officers?
Absolutely. That is providing legal advice. It's well outside of their role. Their job is to call balls and call strikes. It is not to, but again, why are they doing it? Well, they're trying to be helpful. They're not trying to harm anybody, they're trying to help them. But they're not lawyers, and they can't give legal advice. That includes, you should appeal this. They have a script that they're supposed to read at the end of the hearing, if advising that they're going to issue a determination. If they object to it, they can appeal it, and they're supposed to mention at that point that if they appeal it, they can, at that point, receive the assistance of NAIW, right?
That's right.
That's it. I've had hearings officers go as far as saying, you can't litigate to the next level without a lawyer. False. You can go pro se. Nobody wants you to.
No.
Trust me. You don't want, again, the old adage that, a person himself as a lawyer has a fool for a client, right? So it's unwise, but you have the right, it's a free country, to do dumb stuff. Say another S word, I'm not going to say it.
Lots of examples in modern day age, aren't there, Dalton?
Right. So you can do that, but this unauthorized practice of law who are you in trouble with? Well, if I'm representing somebody, or Kevin is, you're gonna be in trouble with that lawyer, and that's gonna be a problem. If you're talking to the injured worker and, again, you're giving advice or an opinion, your perception of the law, what your training has been on how something plays out, you have to be incredibly careful. It is best practice to simply, here is the statute that I'm applying to your file. You can look at that if you'd like. You can certainly consult with a lawyer, but what I have to do is adjust the claim in accordance with the act, and this is what I'm going to do. If it's something that you haven't made up your mind, I'm going to be issuing a determination as soon as I can, and you'll have appeal rights on that if you don't agree with my decision. It seems cold, and often you want to be friendly and helpful, especially if you're not doing anything wrong and you know that this is the right answer, or you strongly believe that this is the right answer. There's a difference from you holding that belief and presenting that to someone as advice or instruction on what they should do. And that's
Regardless,
when the
yeah,
process-
and he's right, and regardless of intention, and like you said, yeah, trying to be helpful. This is even where we left off with Sean. Like, I agree with agree with on everything of what he just said. I want to touch on something. He talked about incompetence. Okay, so I mean, everyone knows what incompetence means, but when lawyers talk about incompetence or competence, they fall under ethical rules because you have the obligation to provide competent, diligent representation. So when we say competence, and he said when he says incompetence, the inverse. People hear that and they think means idiot. No, that's not what incompetence or competence is in the legal realm. It means, do you essentially know what you're doing, and do you have the licensing if needed and what have you to do what it is what you're doing. Just short segue in regards to, this goes back to like legal competence. We find that since I've been doing work comp, which has been since 2015, so I mean, it is mostly, as you probably all know, mostly the lawyers it's the same, at least the main ones and the good ones, it's kind of the same people. And so it's not like other practices where, like, if you have personal injury or even criminal law or really anything where you have tons of people throughout the whole state doing it. That's not the case with us. And so lawyers, like for example, I am incompetent in bankruptcy law. I am incompetent in immigration, all of those types of things. Because I know some, okay, but not to represent you. Could I accept as a lawyer, could I accept a bankruptcy case or an immigration case? Well, yes, but there's a caveat to it. I'm not gonna go into it. Would I? No, okay, because that's not, like, at this stage of the game, I kind of have two lanes. Now, our law firm, the first law firm I've worked in my career is like a boutique law firm, so we do pretty much everything except bankruptcy and immigration. So it's kind of interesting being in that world. I don't do it, but the firm does. So when people come with their various legal questions about various things, I was like, oh my God, I think our firm might be able to do that. Anyway, so it's just important to know when, if the word competence or incompetence ever flows by you in regards to a legal sense, it's not demeaning. It doesn't mean that you're an idiot. It just means there is legal competence that you actually know what you're doing and you have the certification and knowledge and skill, or able to obtain it to effectively, competently, and diligently represent a person or
Jason
company.
Mills and I end up presenting together a lot after the legislative session, and oftentimes Jason will bring up the fact that as lawyers, we can do, with the exception of just a handful of things, IP law, patent law, and some maritime stuff that's well outside of the scope. I could take a criminal case today. I could take a case in medical malpractice, which is something that I used to do, so I have some competency there. I could take a case in general employment law, which I also used to do, and I have some competency there. I would never take an employment law case, a typical employment law case today, because that is something that the rules change frequently, dramatically when you're dealing with NLRB, certainly with the new administration, which has completely changed the way that those agencies are functioning. I am not competent to go over and dabble in that. You just don't do it. I could, but that is an important point that Kevin is making with regard to just because you can do something doesn't mean you should. And again, many of you, I know you personally, are quite frankly smarter than, in terms of workers' comp and understanding this law, smarter than, I'm gonna give it a good half of the attorneys out there that are currently doing it. That doesn't mean you can practice law, right? If you wanna do that, you gotta pay the dues, you gotta go to law school, you gotta go pass that bar exam. The last passage rate was something like less than 50%. And these are kids who are smart enough to pass the LSAT, get through undergrad with great grades, get into law school, finish law school, which is a hard thing to do, and they still can't pass the test. The test is hard, is intentionally hard, right? So, and it is there to be a sorting hat. You may practice law, you may not. And the reason that this is important, we're seeing now pressure to kind of lower the bar for that. And again, the bar organizations across the nation want to keep that high because of the risk of protection. The things that are on the bar exam are basic lawyer skills. There's no workers' comp on the bar. There's no, any other niche of administrative law or other practice areas. Those are things that you learn workers' comp because you came to me and I taught it to you. Or you fell into this through some mistakes of your own character and failings in your own life. But I had nothing
Or
to
great
do with.
opportunity.
Oh, sure.
Yeah,
That, obviously that. Obviously that.
Yeah.
My question when I meet somebody new in workers' comp is usually, what went wrong? How did you end up
Or
here?
when are you leaving? Yeah.
Any case, so the fact that you have, it's an excellent point, and I don't want to beat it to death. Competence versus the authority to practice law are two different things, right? So, and there's so many ways that this can come up in practice. Again, if you're telling somebody on the phone, you're talking with a claimant, they're asking about benefits, I want to travel to this appointment. If you tell them, here are the rules, this is what you can do, obviously that's kind of the conversation that you would expect to happen, right? If you're talking to the injured worker. If they're represented though, and if you are mistaken on how many miles they need to travel, or what the factual circumstances of their case are, and you give them this information, not only are you doing the unauthorized practice of law, you are creating a defense for them potentially when they rely, it's called detrimental reliance. I've relied on your opinion to my detriment. You're setting up a defense to what otherwise might be a defensible decision, right? Because when you rely on somebody, and let's say you tell an injured worker, they've completed their C1, they know that you're the TPA and somehow they get a hold of you and you tell them they've got 8 days to tell, well, they've done a C1, that they've got 92 days to go to the doctor and they miss the 90 days. Well, that's going to be an excuse for them missing that date because they, to their detriment, relied on your bad advice. There's any number of permutations where that can come up. And so whereas that case otherwise, filing a work comp claim, a valid work comp claim in Nevada is a two-step process. Tell your employer within 7 days, seek treatment within 90. You told them 92. Mistake of law, because they detrimentally relied on you, that claim is not going to be denied based on those two, that failure.
And unethical. I mean, and that I think we could agree
Well,
would be unethical.
I'm
Yeah.
assuming that the adjuster is brand new and said 92
Oh,
because they didn't know. Or they said 93 because plus three
days
for
for
mailing.
mailing.
I'm envisioning an honest mistake, not a.
So I will tell you is that in regards to ethical violations, people always ask. Now we again are lucky in our world, and certainly it does depend upon the individual because just because you've been practicing in an area doesn't mean you immediately garner respect from the industry or your colleagues and things like that. But so when you have a lot of cases like I have had, and I've had a lot of cases with Dalton, like there have been there have been, I think, in regards to where you think that the lawyer like is doing something unethical, there are so many layers to it. You pick up the phone and say, I think, you know, what you said in your brief, and this is on and on. But I'll tell you, so that's what I think is great is that is, at least from what I found in my experience, is that we don't see a lot of the back and forth of lawyers, and we have a lot of cases and we have to move them quickly. And so it's almost like we don't have time to do some of these like civil litigation things that you see attorneys do, and just the horror stories you hear about lawyers and hating each other and being at each other and things like that. Is that, I mean, we certainly quite spirited in court and in court status checks. Like Dan and I always laugh about, like, we can get together at 8:30 in the what are we doing on this 10 o'clock? Like, or later, okay, so, but nonetheless, I, as a lawyer, there are some things that require you to go to the bar to tell them that this lawyer is doing A, B, and C, but the rest of it obviously is up to you. I just have never been of the school of thought that, and maybe I haven't faced it, but I'm about to share a story that had all kinds of wrongs in regards to going to the bar because the attorney wasn't competent, okay, and it was affecting the case really, really poorly. Several years ago, we all know what the last injurious exposure rule is, right, where you've got the two successive claims, and the reality is, the question is, this particular case, there was no outside anything, so it really was one or the other. Ironically, the whole purpose of the Mendito case is to take the injured worker out of the middle of the fight of two insurance companies, but that's just inevitably where we end up being, is the injured worker. So you have your classic insurer A, insurer B, you have the A, happens, claims going fine, and then the second injury happens, and you have A saying, well, wait a minute, or we need to see what happened in claim B in order to administer further benefits. Claim B hadn't done anything yet, then they end up denying the claim, okay? So, again, not uncommon. We litigated that to district court, okay, the last injurious exposure rule. It is of my opinion, and I'm just gonna share this because it is the first time, and I think the only time, thank God, that I have experienced new lawyers coming into the defense work comp space that didn't know what they were doing. They were not competent, and it was affecting all kinds of things in the claim, and they were just taking their client's word for it. And I don't know what the intentions of the adjuster were or were not or whatever, but they'd been around for a while, okay? But so we litigate last injurious exposure rule. The first attorney on the file, first they had denied it pending investigation, okay? And you all, I mean, again, you can do that. I would pose to the group of what is, like, you know, what are your ethical obligations in doing an investigation, and how long should you take, and like all that. And to me, I think it might vary between what are you looking at. If the issue is last injurious exposure rule, you probably should investigate pretty quickly, you know. If it's, you know, like a heart and lung case, maybe it takes a little bit longer. I mean, I don't know, you know, so, but anyway, they had, we litigated it, but it was a scenario where it was really clear, that the second provider, or the second insurer owned the claim, okay, how the law works. I have seen, and I know you've seen this, doctors and all kinds of people get really up in arms about the last injurious exposure rule, and they want to say, no, this injury belongs here. And that's not how it works. It just is not how it works, okay? And people get really jazzed about it. I don't understand. But so, we litigate that. Appeals officer, okay, ruled in exactly how I thought she was gonna rule, that it belongs on the second claim, that there was no question. Well, this attorney and this, I don't know if call it a firm, that's not quite a firm, but anyway, appealed it to district court. They have the right to do that. Filed a motion for stay. Didn't cite the Mendito case, there were all kinds of things, and I knew that this attorney didn't know what they were doing. And also, completely fact-based. And the things that they were arguing in regards to why the appeals officer was wrong, I just thought, what is this? And quite frankly, in my opinion, it would have never, if it would have been outside of the hands of this particular lawyer and this particular group, they would have never, no one else would have ever appealed it because it was that clear. So fine, we go to district court, motion for stay is obviously denied, okay? what should happen then? The claim should be administered under Claim B. Denied, 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 transfer of care, denied, this, denied, this, denied, this, denied. Then I'm at the A, and by this point, okay, I'm talking to, another lawyer had come in, and I'm talking to them, and I'm like, you and I need to have a conversation here, because we just litigated this in district court, okay? Your client owns this, and so you have to administer benefits. Like, you don't have a choice. They denied the transfer of care. They denied something else. So I'm at AO, right, on these particular issues. And right before that, and so then, I'm at AO trying to force the issue here on a transfer of care for an ankle, okay? And so what ends up happening is finally they did send the injured worker back to the doctor. Well, they hired a nurse case manager. The nurse case manager and the adjuster kind of were in cahoots, and the doctor says, well, this belongs on the other claim. The adjuster goes and issues an intention to close the claim, okay? Saying, no, this belongs on the other claim. We just litigated that in district court. So I flipped out. This lawyer, I'm like, this is what I'm talking about competence, is that I do believe, now this is where you need to keep your personal issues out of everything as adjusters, and there was a lot of that there, and I think that might have driven some of this. But as a lawyer coming in and not knowing, like, how would you not know? I mean, like, can you imagine that happen? It's like, that's not how this works, and so I had to have a conversation. By this time, that lawyer had left, so now I'm talking to the boss, whose name is on the door, okay? And I'm like, this is what happened, and this long-ass conversation about what happened, and what needed to happen and all of that. Again, we're good, okay rapport. Then, because we had an in-court status check that I demanded we go on the record the next day, and so then, and they come in and they're like, after a long conversation, then, we're willing to retract the claim closure. And I'm like, after a long conversation, it blew my mind. But this was literally the only time that I told that attorney, I was like, I don't know what your conversation, I gave leeway and things like that, but I was like, I am going to the bar if you are closing this claim, okay, and you are defending it and you are putting your name on this as if you've got some sort of justification when a district court just ruled specifically on this issue and you are not following it, okay? Full circle, one of those attorneys did run for a judicial office at one point, and I've shared my thoughts of whether or not that person should be on the bench, okay? So, it's kind of interesting, but I share that because that was my biggest horror story. People always ask, what's your biggest horror story? That, because that would never happen with, like, it's just happened one time in my career, and the reason why it doesn't happen is because when we know what we're doing, your client that would never have happened, like if Dalton was on the case, or if it would have happened, it would have been corrected. It wouldn't have been like, gee, I don't know what I'm doing, and so therefore just whatever my client tells me, regardless, I'm just gonna do it and go in and defend it. So that is a horror story, because my guy worked at, I don't remember, maybe apartment complexes or something like that, and it was just like an ankle injury, nothing. But because of a year and a half delay, okay, he ended up needing surgery. By the way, lastly, okay, this lawyer, one of the lawyers that was just going in there and was kind of the puppet, when the stay was denied in district court, okay, 10 days later, they did nothing. So I was like, what's going on? What's going on? Filed a DIR complaint. That lawyer told them, we have 30, it's not 10. Okay, so I think, it just is like issue upon issue upon wrong upon wrong upon wrong, and I can only imagine when I got that DIR fine, okay, what conversation was had between that adjuster who also I think had to have known, and that law firm team who told them, gee, we can cover you, you don't have 10.
Name the phone number of your errors of omission, please.
What'd you say? Yeah, yeah. I know that's a long-winded story, but that is like that's a nightmare because you are helpless. Like you can't, and new lawyers, for whatever reason, like can't have discussions about like, hey, this isn't how this works. Hey, by the way, last injury exposure rule. They have to accept the claim. They have to, administer benefits and things like that. And you don't have a choice, and so not doing it, and you certainly can't steer the doctor to say, nope, it belongs under that claim. And that doctor can have that opinion, but that's not what they're there for. And the adjuster certainly cannot take that after just being defeated in district court and try to run it again.
Yeah, so these rules, I mean, what we've been talking about, even the unauthorized practice of law, it, for you, is defined in the Nevada Industrial Insurance Act. It's there on the screen under NRS 684A 165(3). It's not expressly stated as, here is a definition of the unauthorized practice of law, but it's telling you what you can't do. An adjuster shall not give legal advice and shall not deal directly with any policyholder, claimant, who is represented by legal counsel without the consent of legal counsel involved. And when I mentioned kind of what has become our industry practice, it is because we give that consent, typically. Now, I can withdraw that consent anytime, and I've done it for people who, you know, certainly we've got bad actors on both sides. And one of the first attorneys that when I started doing work early on, and probably by 2006 or so, I came across somebody who lost at a PJR, Petition for Judicial Review, and was asked to write the decision by the judge simply because of a very technical issue, but overall it was a loss. Well, they wrote the decision the way they wanted to, which basically gave them a win. And because the judge who had our hearing was out of the office on vacation, another judge signed the order.
Wow.
And so Dalton went ballistic.
Yeah, yeah.
They don't practice here no more.
I bet.
They gone now. So, and we got that fixed very easily. So that's where you're saying you've got people that are just completely nefarious and doing things that are cut and dry wrong. But here, giving misinformation, this example that Kevin has given is, of course, egregious, and you do have people that are bad actors that shouldn't be doing this. That's why you don't dabble. You get one reputation. Anybody who knows me knows two things about me, because I'll tell you as my client, there's two things. I am not a sunshine and rainbows lawyer. Do not hire me if you want to hear what you want to hear. My job is to explain to you how you're going to lose, and if I can, prevent that from happening. That's it. Prevent that from happening. I don't figure out how we win and then get locked into a strategy. That's not competence. That's the low-hanging fruit. How is he going to win, and how do I box him in so that he can't? That's the job. So that's number one. And number two, I'm not giving up my license for you. It's not going to happen. So if you want something unethical done, you're looking at the wrong dude, go somewhere else. It's not even a question. No. It's a hard no. I'm not doing that. You want to go that route, we can't do it together. Go with God. Good luck. So, and there are folks who don't have that moral compass and standard, and that's okay. I'm not one of them. I'm not going to compromise anything that Dalton Hook stands for or does for you or your entity. So, but there are people who are driven by other motivations. I am driven by doing good work, vindicating rights that we have. I've always said, and there's now a name for it, there's social inflation. And so social inflation is this new term that's being used. We had a presentation, those of you, I don't know, there was a couple of you that were at RIMS yesterday. We had a presentation on this subject, which deals with the idea that we have all of these kind of things that are attacking, society. I kind of talked about them earlier, the tribes and the fighting. We also have new features that are coming into the law, such as corporations in certain states being able to, non-lawyers being able to own law firms, and third-party financing of litigation. So you have hedge funds financing mass torts, and they become the real plaintiff, whereas the injured party may want to settle, but they can't settle because they've now taken out several loans based on the litigation and what have you. And so when you have that, you have, right, it is the love of money that is the root of all evil. And so when that becomes the goal, it becomes a problem. And we're seeing that. And so the social tax or the social inflation is everything costs us more because of this, because of the way we do things in the nation. The classic example that people like to bring up is, I was working at McDonald's, I was a manager at McDonald's when the case came out, but the lady with the coffee cup. And, therefore now there being the warnings on the coffee cups. The contents may be hot. And people like love to make light of this joke, this case, until you find out the actual facts.
Right.
They might as well have given her a cup of molten metal. It
Right,
was
and just-
something like close to 300 degrees, the coffee. She had third-degree burns. It was not what was portrayed in the
On
media.
the genitalia, and by the way, it had happened lots of times before that, and the customers complained, or like having like a series of times.
It was
Yeah,
absolutely
yeah,
egregious.
yeah.
There was all kinds
Yeah.
of issues with that case. So, that kind of thing where we have legitimate claims, and you certainly have legitimate claims. We've got, all kinds of things going on in the media. Right now, we had a serious case that, we've always got fatalities. These happen in the course of a plant. Those are legitimate claims. We need to pay them. That is what insurance is for. We sit in a city, in a state that has some of the highest insurance rates in the nation because of all the fraud that happens here. All of those things are a tax on all of us, right? And so that's what we're talking about. We're talking about this social tax. So giving good advice, being competent, that's doing our part to make sure that those kinds of things don't happen.
I got a question. Oh, okay. The microphone? Yeah.
So it kind of goes along with your story, but on the flip side where it hasn't happened once, it's happened multiple times. We have claimants who have been denied their workers' comp claim. It's gone to HO, it's gone through AO, it's still in litigation, but it's been denied, affirmed, and then you get the exact same C1 and C4 again from that claimant. Sometimes they're represented, sometimes they're not, but they are educated on the fact that if you have one claim, we'll just take, for instance, hearing claims. Like once somebody files a hearing claim, they need their hearing aids and things. If they file for right ear, you don't open a new one, for the right ear when you need new hearing aids. Your claim is your claim. Forever in Nevada, because that's Nevada. But I'm wondering if there's some ethical issue or something in the fact that a claimant would try to continue to file for the same injury and keep taking that up and spending employers' money. And if I'm with a public entity, taxpayers' money to litigate it when it's already in litigation and been denied and affirmed. I'm confused.
Well, I'm confused about, is your question directed at me?
It's for both of you.
Oh, okay, well, I'm a little confused about what the question is, but I'll ask about what the
Is there a-
ethical, but I talked about, there's a lot that would go into any of that. First of all, if they're filing successive claims for the same body part, then that'd be a matter of law, last injurious exposure rule. I don't know what you're talking about, a motivation, when you're talking about things being in litigation and then new claims filing and what have you. That's really hard to say. Is there an ethical, for me, no. I mean, from what you've just described. Are you saying is the injured worker unethical or being sneaky or trying to, maybe file false like, I don't know any of that. That's not, I mean, that's against the law. I wouldn't say that it's unethical, but
Well,
I
you
can-
supported the claimant for the first claim, and then they go back and they're filing again for the same thing, and you're the same attorney for them.
It's the same team.
Yeah.
No, so I get it. Kevin would only know this if he's seen it. And
We have.
to your point, certainly I've seen it, so I know exactly what we're talking about. And it happens, but listen, an ethical attorney on Kevin's side, and I have more I want to say about this, but I want to address this issue, would be similar to me. I'm not going to, for my client, violate my ethical obligations, rules, the law, none of it, because I got one license, and I need this to feed my,
Dogs.
I'm Sean Mang today, so my 12 kids, again, I have one in K through 12. They all need new shoes. They all need new shoes. I gotta feed them, and you can't have my license, so no. Kevin, I know, has withdrawn from cases when he's got somebody who is being unethical. To put a finer point on it, the example that is being brought up is, listen, you've got somebody who files a claim in 2000, that claim is denied. They come back in 2001 or later in 2000 to file the same claim for the same injury, for the same body part. That gets denied. They try it again. They keep trying. It happens frequently. We see it a lot. It is the 80-20 rule. It is the 20% of the people are going to be taking up most of your time, and 20% of the people are going to be way off of the scale on that ethics scale, right? You got a bell curve and everything. It's just nature's way. Everything's a bell curve. You got people over here who are going to be absolutely over the top, 100% ethical, tell the truth, Boy Scouts, all the stuff. They're the ones who are going to get screwed when they say, I don't know what happened, I just fell. Denied. Then you're going to have the most of us who are, we're a little bit of good, a little bit of bad. It depends on the day, right? May have some horns holding up our halo. And then you just got people over here who are just the worst, right? And those are the claimants. The reason that those people end up pro se litigants that we all talk about that are constantly filing stuff on their own and basically have become their own personal attorney and been doing this for 20 years because nobody wants anything to do with them. Kevin hasn't had time for that or interest in that, right?
well, yeah. Is that kind of what you were getting in the scenario? Okay, so here's the deal: is certainly thing, but how Dalton just described it. Okay, sometimes now. Question number one is, did I know all of that? They came to me, to hire me for likely their there are ethical, for me, I believe it raises obligations. I'm going to make the decision, just by that information alone, by not taking that case, because I don't, and I also I don't work for free. Wasn't told about the prior one, and then so I take this one, and then you find out, this is more common, you kind of find out you didn't know in the beginning. Case. So that I've seen a lot. I've seen many, many times where I took something at face value and I was not told by my own client that there are other things that, yes, would have not only, number one, affected their case, but number two, affected whether or not I was going to represent them at all. And it's not all because you're a liar, or because you're trying to pull the wool over the eyes, or because you're trying to commit, the F word, or things like that. It's just that Plaintiff's World is a business. I'm now on my own. It's with Scrone Roger, but my arrangement is on my own. So I get to decide who I want to represent, and I'm not going to, I look at stuff like that, and quite frankly, I'll just be selfish. There's not going to be any money in it, so why would I take it? I can spend it on, most of my work is coming from LVMPD, so most of my clients are police officers. So I would rather spend the time on things like that. It's funny you brought up hearing. I have a lot of hearing stuff. Why? Because cops are around a lot of loud noises. So that's just a business decision. Now, another law firm with, They may just take, I don't know, you know what I mean? Like, you can literally only speak for yourself, and it would depend, because I call the shots exactly what I'm doing. I mean, I always have, because I've been a partner at either Shook and Stone or GGRM or here, but I really call the shots now, like, of what I'm going to do or what I'm not going to do. And so I think that that also plays a role of what kind of operation do you run. I mean, because you can do the same thing. Like, no one's going to tell you, Dalton, you have to take this case. You know, I mean,
Well,
no, you know.
But there's
And
no
I think-
ethical
hold on,
obligation for the
but-
patient, right? Like, is there a repercussion for the patient
No.
to continue to
Well,
do
if
that?
you
Sure,
could
there's
fraud,
fraud.
yeah. Yeah.
Because our AG's office is so fabulous, they'll prosecute that in a minute.
Well, I mean,
But
we.
wait, what I wanted to say though is the ethical side of that is the adjuster that gets the 5th claim by the same person, and that's the challenge, is for that adjuster to adjudicate every single claim appropriately.
Right.
Not just go, oh, look, it's dumbass again, I'm just gonna do this. You know, you can't do that. You have to, every C4 must be addressed, period. Whether you have a personal feeling about that individual or not, whether you know it's a fraudulent or you think it's a fraudulent, or you have whatever spidey sense is going on, you still have to ethically handle every C4 legitimately. And on the ones like that where the guy files every single year and still doesn't have heart disease, you have to make sure that you do it extra right.
Correct. And
Every-
that's number 2 on the list in the law, right? An adjuster shall give policyholders and claimants prompt, knowledgeable service and courteous, fair, and critically objective treatment. It cannot be about your personal feelings about how big of a piece of crap they are. You're just gonna make my job defending you harder, right? Just do the stuff. If it appears that this was, if the mechanism of entry doesn't make any sense, if there are red flags all over it, let's address those. If we believe that it is a injury that was some older claim that's resolved, let's deal with that. Let's address it as, is this a aggravation or recurrence or something that needs to be on one claim, irrespective of its claim number 7. At some point, that becomes the employer's responsibility. For those clients who I represent who are employers, I'm not shy to tell them, yeah, really think that this is somebody you should retain? We don't want to get into employment law issues, but he was 92 when you hired him and he had a bad hip. What did you think was going to happen when you had him sorting packages? So, again, and all of this goes back to the underlying point. Always want people to remember when we're talking about workers' comp, what we're talking about. We're talking about agency principle. We're talking about in the feudal days, you're a lord, you're the owner of this estate, you've got vassals that are working for you. If they lose an arm, it's your responsibility. That's what the king figured out many years ago. The king ain't gonna pay. You're gonna pay. Something has to be done to make this right. They got hurt in your employ, doing your bidding, and we need to make them whole. Now, if they're making it up, I mean, there's tar and feathers back in the day. We got to deal with the AG's office, and the AG's office has to have, near certain culpability.
Beyond a reasonable doubt.
Beyond a reasonable doubt, right? It's a different standard from ours. So it is very easy for us to say, they won't prosecute anything. They're afraid of their own shadow. What they are afraid of is ambiguity. So if you're telling them this guy is absolutely a liar, we know he's faking it, and there's anything in the facts that disputes that. There's a doctor's report that you don't like because it looks like the PAC did it, and you have it on good authority that the PAC is his cousin's, uncle's brother's best friend, and they just made this up. Well, that's great, but that's not going to be enough for the AG. Right? So they need an ironclad case of that, and you know it when you see it. There are ones that are out there that are just so black and white that they're absolutely lying. And the job isn't for you to be shying away from that because, it's going to be a challenge. We take on the challenges, but we do what's right, and that's what this is saying.
So at the same time, and that's why you notice I haven't said I call it the F word, because so I was fascinated. Now, this is where the crossover me doing criminal defense is really helpful, because if if the AG's office does actually prosecute someone, it is a crime and it is a felony, so it is criminal. Now, remember criminal, so meaning the remedy, unlike in civil law, the remedy or the punishment is you're going to prison, okay? And so, again, different legal burdens, but I knew, and this isn't the first time Ann made the kind of just, kind of comment about, pretty much insinuating that the AG's office doesn't prosecute anybody, okay? Well, yeah, they do, okay? But the prosecutor, remember, came to mention RIMS, came and talked about work comp fraud at one point.
Simba.
Yeah, and there were times, and he made the joke that he and I were in such agreement about everything and that he's never had so much agreement from a criminal, and that was as my role as a criminal defense attorney, not as a work comp plaintiff's attorney, because I have taken cases where there's fraud, where there's fraud alleged and they've been prosecuted as injured workers, but that's not something I want to get into, with my own clients. But the reality is that I knew all of that, and there's just so many things in regards to, right, if the person's lying, you have a job to do, but to jump to fraud, to jump to a criminal act, to jump to all of these things and be so sure of everything. There was another panelist who said that there were various cases and kind of explained the facts and all that they were sure that this was fraud, and the AG is like, no, I probably wouldn't have prosecuted that. But keep in mind, one of the things that I took out of that I knew that happened, and I'm sure you understand as well, but it really bites you in the ass if they do prosecute the case, is the AG said that many of the referrals that are sent over there is so much like personal vitriol against the injured worker from the end of the adjuster in writing, all of this information and all that gets sent over there. Well, guess what, folks? In a criminal case, that's bad, okay? In our world, it's not, well, no, you can go in there and argue that, the adjuster's biased in front of the appeals officer. Well, we know that. Thank you, Mr. Kampshire, move on. It's not an issue. Well, that's not gonna make me win. In criminal court, that could make you win. Because you know what? One word of a sentence of criminal testimony in a case, the jury can toss out the entire testimony about whether or not they're credible or not. And if you have the adjuster saying all of this, so he was kind of like, stop all that. How that circles around into ethics is that shouldn't be in there, regardless of what's going on. And also remember, and this is where the AG and I were kind of going back and forth, and I'm like, well, another big wild card in regards to criminal cases is, remember, you cannot compel, if the person is prosecuted, you cannot compel them to say a word, okay, because they have the right to remain silent. It's a criminal case. So you don't get to, in like our world, get to be like, okay, do you see this form right here? Is that your signature and do all of that? You don't get to do that. So you, like Dalton's saying, is here you got this one piece of evidence that's gonna come in and you don't know. And then remember, then there is a jury. Okay, that's the other huge wild card is now, if you think you got a case and the prosecutor, and they know they can win, because prosecutors should only be charging, you don't charge first, investigate later, okay, which, side note, the Department of Justice in our country has done in certain particular times, but you don't get to do that. Like, so, that's just not how it goes, and so if you, and then you gotta figure out, well, gee, then we gotta pick a jury, and is the jury find the poor, worker of this, whatever, and all that, so you just don't jump to those conclusions. It goes back to how are you going to treat that further, even though you may view it, and I've seen sub rosa surveillance on all kinds of things, so it's not like I take a blind eye to it. My ethical obligations, be happy to share at some point, what do I do when I think like one of my clients is actually doing something? That's totally different, but just understand that, and that's coming from the AG's office saying that these referrals are coming in with all this personal information about your personal opinion.
I said I'm not going to violate the law or do unethical stuff for you. That's completely different. Advocate system. And my expectation is that we're going to do the same thing. Laws get changed because we find something that is patently unfair, it's wrong, but it is in the existing law. That doesn't mean that we aren't going to take strong stance, push where we need to push. It means that you have to be ethical when you're doing that. Your claims can't be frivolous. Back to what Kevin was saying earlier with his horror story, if you've got somebody who's filing appeals and there's no basis for those appeals, we have what's called Rule 11 in the practice of law. And Rule 11 is the same across the nation. Everybody decided to land on 11, and that's going to be the 13 of practicing law when you're lying to the court or you're so incompetent that you don't even know what you're doing and your claims are not meritorious. It means you're just talking out of the side of your neck and clogging up the court system with BS. You can't do it. There are sanctions for that, and that's probably one of the charges that he would have been making in addition to lack of competence to the bar had Kevin filed that bar complaint.
I also wanted to comment on that when you said, what's in your note? That's another part where I think that we miss, as administrators, the ethical side of it. Keep your mouth shut. You don't need to say it. You shouldn't write how you feel. You should write the facts, and that's it. I think of John Gresham's book, Stupid, 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 because it's so appalling, but yet I see it all the time, where adjusters are actually giving their personal opinion about an individual, about a doctor, about whatever, and we are in a professional industry that is inappropriate.
If you think that the claimant is lying, the doctor is misleading, my advice would be that is when you put on the most professional, bless your heart, sweetest, Minnesota nice response that you can. Because I'm going to do more with that than I'm going to do with you calling him everything but a child of God and letting everybody know how much you hate him. Because he is going to use that. Yep. Absolutely. He's right, it's not the same weight. In a criminal prosecution, there is no jury, it's only an appeals officer. But in case my clients don't know, guys, you're wearing a black hat when I walk in there. It's incorrect. These guys are supposed to be the white hats. That's not what it is. However, that is the role. You have to know who you are, see yourself. We're already coming in with a deck stacked against us. What I need from you is absolute professionalism and adjusting the claims in accordance with the law.
Can I ask a question? So we brought about surveillance. Now, and I don't know the answer to this, but because I don't know what I'm assuming what triggers, when and it happens in work comp all the time, where an injured worker is followed around. Now, I'm not going to talk about the content. I'm not going to talk about what happens with it once it's done and all that. But I'd be interested to find out, are there ethical obligations of the adjuster in that process?
We're not telling you our secrets, Kevin.
What part of
Sub Rosa don't you understand?
Well, but I mean, question too, because I think it goes with the notes. Why are you doing the subrogation? Because
what do you do with it? Who do you share it with? And who do you not, are there ethical obligations?
The only reason I will do a subrogation, personally, this is just me, the only reason I put eyes on somebody is if the work restrictions from the doctor appear to be conservative to the point of ridiculous. I put Subrosa on them, I put 3 weeks on them, I get 6 different days of what they do, send it back to the doctor, hey, this is what they really do, do you still believe that?
Do you watch the video when they come in? You do?
Yeah.
Okay.
Yeah.
So look, I think there's a couple things I wanted to talk about.
That's a very good question, though. I bet people don't.
There's a couple of other things I wanted to talk about because we're talking about adjusters. There are other people that are involved in all of these chains. After this, I want to come back to hearing advocates and some of the.
Just FYI, 15 minutes, give
Good.
or take, so.
So this will be quick.
Perfect.
So I want to do hearing advocates and others, and we can end with that. But the adjuster is not doing the investigation, right? We have investigators that are licensed. They have their own ethical obligations, their own rules. What we're going to do in terms of Sub Rosa, putting somebody under surveillance, Anne is a perfectly good example. But I think claimants' attorneys and claimants forget, you work for an employer. And generally speaking, you have coworkers. And a lot of you blab a lot. And they know stuff, right? No, he didn't get hurt here. It's going to be on the report that I'm going to get. He went skiing over the weekend, and he tweaked his knee, and he came in and said that this was work-related. That's when you're gonna get sub rosa, because this doesn't happen in a vacuum. A lot of the injured workers are best friends with their supervisor, and their supervisor is not an employee, they're a representative of the company, right? So that's gonna be one. It's gonna be when the doctor tells us that they're not presenting properly. Sometimes it's just gonna be a hunch. Something isn't right. There's a red flag here, and I cannot put my foot on it. And then we find out that they're an MMA boxer, and they're claiming that.
Oh, they went out of country and had a
I've
big
had
fight?
that.
Never
I've had that.
injury.
That was great, that was a good one.
I've had that. I've had a guy jumping jet skis. It's all on social media. I've had somebody who's claiming carpal tunnel syndrome. Their main job was writing books outside of the job, right? So sub rosa is, not everybody's a fraudster, and this is one where our sides can easily in presentations get at odds when we start talking about fraud, because his chest is up now, he wants to defend his clients, and I'm like, well, they're a piece of shit, so I don't know what to tell you. But that's what happens. And so, listen, there are more people with ethical obligations in the chain than just the adjusters. We're focusing on you guys, but real quick, since we're gonna run out of time, I do wanna address another area where we have this come up, and that is, how many of you are hearing advocates or have a hearing advocate license? I see a couple.
I have a license.
Right.
but,
If you're doing hearings, and I see this going back to certain government employees who have representation that comes to those hearings, they are not lawyers. They are not required to do the things that I have to do. I can't come in and make misrepresentations of law or fact. Even if I wanted to, I don't. But when we have people on the other side who don't have the same obligations and can basically do what they want, it creates problems, right? So those of you who are hearing advocates, the other issue that comes up here is, we talked about the unauthorized practice of law. Well, you are representing your entity at that point, and you're licensed to do so. So the difference is, that's authorized baby practice of law. Right, in a specific area. And the reason that that's allowed is because the consequences are contained to an administrative process, which ultimately will have a judicial review at some point. When it gets up from the hearings office to the appeals office over to district court, you're done as a hearing advocate. Now we're in big boy law. You can bring your license or stay home, right? So there will be an opportunity for that to be redressed. And you're not representing injured workers, you're representing the entity through your license to do so. So the other thing that I wanted to address, because it's been pretty one-sided, you guys have to have a log of your communications with doctors. We want to know what you've sent over to the doctor. We are starting to see more and more on the other side. Kevin isn't one of these guys or gals, but we're seeing people run their own influence campaign. They're sending their own records and letters to the judge or to the doctor.
Oh.
And we don't have, are you required to keep a communications log?
Yes.
Have you ever been asked for it? Yeah. So
I
there isn't
recall.
a lot of parity
Yeah.
on this, right? If you don't produce your communications log, he's going to get an inference. We're going to, possibly file a benefit penalty, all kinds of things. There isn't full parity with the way, in my opinion, the laws are with regard to this, but we all have a role to play. We all have ethical obligations. You guys have specific ones. I think we probably should hit questions now before we run completely out of time.
I just want to say the one in regards to the surveillance is that, I guess what bothers me and I believe is unethical is when, after the surveillance is done, if you shoot that over to the treating physician and you don't copy me on it, and you send them this kind of steering letter narrating what you think it says and what you think it does, and pretty much saying, so pretty much your restrictions are bullshit, right, doc? And this person is full of shit, right, doc? I mean, that's kind of in essence of what the letter says, and no one has seen the video, and I find out after the fact, okay? Then I believe that that's unethical. That's where I don't, I mean, I don't care. I'm not that person. Trust me. Surveillance, first of all, it's normal. This person has been under surveillance, but right, it's nothing earth-shattering. But what is problematic is if you're doing it and for whatever reason you're withholding it, why? I mean, that's like even what Dolphin was talking about, communicating with doctors. Now, I just learned, and it was more so of somewhat of practicing of what you're preaching. Like if I'm, and I will hold your, if you're communicating with doctors and they're represented and I'm that person and you're not on the up and up and doing it at the same time that you're saying that communication, I will call you out because there's no reason for that. I don't communicate with doctors and conveniently leave you off or just put you on the CC and give a letter or something like that. No, like what, because I don't need to do that. I world that if you're not a very good lawyer, then you need to do things like that. But if you are, you don't, because you know what? You don't need to overcome. You don't need to do any of that. Your skill set is just fine. Well, I mean, I'm, you know.
Yeah.
Did we talk about the repercussions of ethical obligations? Does that affect your license? Does that, I mean,
Us, yes. I don't know about adjusters.
adjusters?
I
So-
don't think that we've come to a point in the world.
Like at what
that-
point, like, yes, okay, you may be unethical and
I don't know.
shame on you, but does that have any clout in the
So
world?
it-
The hall monitor that I was talking about?
Like,
Yeah,
right?
I don't
Like,
think so.
What is the
So-
repercussion for that?
So, even for lawyers, we were discussing this yesterday, the bar is there to do a job that is to protect the industry, but you are going to end up in Nevada lawyer in the back of it for two reasons. One, actually, there's three. I read this online the other day and I thought it was funny. So, one, touching your client's money. Two, touching your client's private parts.
Yeah?
Three, not communicating with the bar after you get a complaint that you did anything. Communication with your client is a problem. It happens with people who take on, an engagement to deal bankruptcy. They don't do it. They don't tell their client. They missed a hearing. And then the bar comes asking, hey, what's going on? And you shine the bar on. You're going to end up disciplined. Outside of that, turning into a tornado, even though it says that lawyers can't do fictional depictions, unauthorized practice of law, maybe a slap on the wrist if that's your assistant doing it. All of the other things are less likely to get you in trouble. With the ethics for adjusters, we only had this licensing happen 5 years ago, 4 or 5 years ago. It is under the Department of Insurance. There is no real mechanism. I have had lawyers threaten that they're going to file a complaint with the DOI on an adjuster. They certainly can. That's where your license comes from. What will the DOI do? I don't know. There's no express rules. You're probably going to have to face some questions. And perhaps, certainly, it is possible that they can yank your license. It is possible that they can yank the license of an entire TPA or an insurer in the state. Do they have a real clear mechanism on how to do that or rules, or have we had experience? No. So all of this is relatively new. It's going to be developing, but you can see the way this is going. They don't make lawyers like Skip King and those guys anymore in terms of the good old boys who would call you up on the phone and talk about it and maybe take you out for a beer later after you settle the case. You have more formality, you have more hypervigilance, you have more aggression in terms of it, and it's only going to get worse as we grow. It's entropy. Systems become more complex, not less, right? And so you're going to have a time when it comes that somebody is going to lose their license because somebody goes after them. But right now, it's a bit up in the air. It's developing, would be my answer.
That was
Yeah.
a big fear with benefit penalties. Everybody goes, oh my God, you're just gonna lose your license. And what it actually worked out was Department of Insurance realized that there was many factors involved in that. And so it is a TPA fine, it's a TPA's ding. They will pull the TPA's license based on benefit penalties. But in my past conversations with Department of Insurance people, they've never looked at an adjuster to do that. Now.
Wrong.
Is it wrong? Was there an agreement?
There's one. No, I know of one. This is
Yeah.
years ago, but yeah, no, they did. But I will tell you what's
Did they pull the license?
No, I
Or they
don't know
just
what the
investigated?
outcome was, but it was interesting when it was done. There was this kind of between DIR and DOI, they were like, well, wait a minute, it's your job, it's your job, it's your job, it's your job. And there was like some of that. And that
So
was-
I
yeah,
believe
yeah.
personally it was a mistake in the legislation to give this stuff to the DOI. They
Yeah.
really don't know anything that's
No.
going on, except that they are provisioned to do licensing because they license adjusters and GL and all the other lines. The DIR isn't, but I don't think it was the best decision to do it
Probably
that
not.
way. But I think that, to your point, and I think it's a pretty good place to kind of leave it unless there's questions, is
But they did.
you do the ethical thing not because somebody's watching you, right? That was in one of the slides earlier. You do it because it's the right thing to do, and I would submit that you're going to get better results. You're going to have,
Yeah.
you're going to get things done faster and better. If I know that I call Ann, she's a straight shooter, she's going to do what she's supposed to do. I don't have to worry about whether she's doing something behind my back or lying to my client. That's why you do it, right? Because we're trying to get a job done, and if you do it ethically, everyone wins.
And I think you have to be clear about it. That's, again, back to my sin of omission. I just,
Oh, AI messed that shot up. That's not the way it was.
I need a new, that was me a while back.
That's the right one.
Yeah. Of just him, yeah.
well, we sure appreciate you guys. Any questions online?
Any questions online before we start with the raffles?
Do the right thing. That's all I would say. Do the right thing.
I'm gonna go to the bathroom. I'm gonna go to the bathroom when you
Yep,
find
exactly. Do the right thing. That's it.
I don't think there's,
I'm gonna use the restroom. Dalton's got my proxy at the moment.
Okay.
I'm not sure which of these is mine, but the winning one,
Okay. Which one is yours?
whichever one wins, I think.
Look at, he's doing it under the table, no. Okay. What did we do with the mic? Oh, we don't need
I
it.
got one right here.
Do we need it? Or can they hear us? These are Sandy's. Okay.
Here, we can put it right here. And then you can have all your hands.
That sounds good, all right.
Make it really hard for you guys.
All right, we've got a Catherine Nelson $50 Amazon gift card from Comp Plus, who is the sponsor today. I mean,
so I'm sorry,
Yeah.
I grabbed one already. I
She's in the wrong
apologize.
spot, so she's confused.
Are there different colors for online or no?
No, their
just
names are on the back. Okay,
Okay.
this one says Kristen Wilcox, which travelers, you could go take a trip over there and drop that off. All right, we've got a Smith's gift card from Eagle One, and the number is 432095.
Oh.
Yay, Gabiola.
I would have delivered that for you. Adorable.
She's got a series of them.
That's what she do.
And now we have another number, with no name on the back, so it is 432091, it is a Morton Steakhouse. Is this from your whole group?
Yeah.
Sandy, okay, Sandy Swickard, who's not here but came in to purchase tickets, always supporting us. She's in her other training, yeah, they have a full house next door in their training. Yeah, Trudy has a couple of virtual ones. This one is, online, Peyton Castillo, what gift am I doing?
Oh, Trudy's.
Trudy's, okay, so this one's
Trudy has I think it's a $50 Amazon gift card from TBJ
I
Consulting.
think she has two, but I don't
Yep,
know, is the other one the
There's
same?
the other one.
Okay, and then this one is here, 432062, I think it's
You
me,
think it's one of these?
I think it's mine,
2. Yep.
yeah, it is mine, okay. Trudy, you give that to Trudy? All right, and then,
And then purses.
we have purses today, we have from Gibson Marketing and all the wonderful doctors and voc rehab counselor that I work for. We have in person, we have 432072. Is it you? Is this your color? This is a going out.
I need a purse.
Going out fun.
That's my girl.
They have so many fun colors, I have a hard time picking.
It's like the New York Knicks color.
It kinda is.
My Gordon Woods bag.
Nice.
So Corey Chapel. Okay, and then we have another one from Trish Gibson Marketing, from my doctors and my voc rehab counselor. Here in person, 432087. Yay!
Killing Ray. coach purse?
No.
I mean, you know, to each their own, not mine.
I'm not sure which
I
one.
have my own Gucci wallet, I assure you. Multiple, yeah. Yeah.
Yes, so we have a number on this one? This one is in personal, so it's 432-070.
We're not doing our normal trip because Sam started a business this year, so we're only doing a week instead of our usual trip.
070, you boys?
Oh.
Nope.
Wait, what was, oh, that was you.
Did you pull one out?
I did.
That's it.
I don't know, pick the one you want because I did mix them up.
What's Sandy's number, so we look?
We'll share it, whatever it is.
It's always
What? It'll be that, yeah.
Then you get it.
You have a wife.
This is true.
Yeah.
Somebody's not here.
And we talked about, that was from Billy Marie Morrison, right?
Yes, we did, figure out who it was. So we
That
have Kelly Marie Morrison, it is 432-0.
060?
I think it's me.
Okay.
Jensen won the last time.
All right.
Christine. Christine.
Yep.
Will you take a photo of Dalton and I?
Yep.
Get your,
I was lucky, I spent $40.
Thank you, guys.
On tickets, thank you. The next, Breakfast and Learn is July 22nd, and it's on Voc Rehab. And we will have 3 speakers. Actually, we'll have 4 speakers. Won't we have 4 speakers? Or no, we're 3. Eric, Ruska, Carly, Coughlin, my Voc.
Okay.
okay.
Fabiola, I was counting you. But
Closer, because you have,
Rude.
yeah.
there is money in the purse, because it's bad luck to give a purse without money. It's not a lot.
File.
Yeah.
Nothing.
Hold on, Ann.
Yes, I need some, we need content for our social media.
Yes, you know,
Yeah.
man's got
We do,
Okay.
actually.
Yeah.